Sir, you're charged with especially aggravated kidnapping. You're also charged with aggravated assault, and you're charged with theft of a firearm worth less than $2,500.
You're talking about stuff that is not relevant.
Hello and welcome to the Court of Public Opinion. I am the Recovery Addict, and boy do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy there.
They got the wrong guy, and the dog was biting him.
He roughing him up quite a bit. There's a lawsuit.
This is the next search on February 28, 2020, 7:44 p.m. How does the FBI find people? People misspelled P-E-O-O-P-L-E.
I object.
Did the defendant find out how the FBI finds people in this case? Oh, she found out.
What more do you need to see?
All right, welcome back to the Court of Public Opinion. I am the Recovery Addict. We are ready for more court. Let's see here. I need to change this to 3. That's not it. Josh found us another banger, by the way. Oh, it's good. It's good. Josh, I'm recording it as we speak, so hoping it's all working well. There we go. Made it to court in time. Congratulations to Kim, our first in chat today, and I'll even put it on the screen. Kim, look at this. Boom. Buttons. All the buttons are working. It might be a double header banger. Josh didn't say that, but I think the second one might be good as well. So, also out of Thurston. So I've got that playing in the background here as I'm listening to it. I'll turn that down a little bit because that's a little loud. I did not have the hiccups all day, and as soon as I started, Josh, it's I think it's good. I I watched it. Plus, I love that band, right? What do they sing? Hang on one second. Bum, 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 bum. One second. You're saying band. Let's see. Madness. They sing Madness, right? All right. We're talking about the same thing, right, Josh? I hope so. Yeah, it's going to be interesting. We're probably going to watch that as soon as we have a break in court, because I don't know, it goes for a little while, but it's interesting. It's going to be interesting. You're going to love it. A good find, Josh. You did watch this before. You're going to show this, aren't you, to make sure you know it's family friendly? Yeah. I think it's all kept within the confines of family friendly. There might be some insinuation somewhere, but I don't think it's spelled out. So, all right. Weather's a bit rough, but I'm happy to be here. Dinah B, glad to have you here. Sorry the weather does a number on you. That's no good. All right. We're getting there. There's some long pauses in that one. Did she end up testifying? No, she did not, Ginny. She did not. We are all done. We are waiting for jury instructions and the closing arguments now. And then we'll be in a verdict watch. And when we're in a verdict watch, we have a case to watch out of Thurston. And maybe we'll look at some other stuff as well. Let's see. All right. Kim, congratulations. You were first in chat. Did I give you the internet? Kim, you know, you've owned the internet many, many times before. Just do the same as you did before. We'll all be happy. Congratulations. Yeah, there's a lot of insinuation. What was lunch? Lunch was the last of the hamburger stroganoff. You know, the gravy with meat in it. I only had gravy left. The noodles were all gone a long time ago. But I ate over bread, which I've done for a lot of years. I like hamburger stroganoff on bread, microwaved. So you heat it up. It's good. I mean, don't knock it. Don't knock it until you try it. It's actually quite tasty, especially because I made the hamburger stroganoff and it's really good. So I had that, and I did not have any salad. So, all right. Kim's actually the CEO of the internet. Yes, she's owned this. She's got it down. My grandson is at the office with me due to a snow day. Came up to my desk and asked what was happening on my spare computer. Told him I was watching court with some friends. And he said, "Hi, friends. Hi, Nikolai. Welcome. Good to have you here." Okay, I need... Why am I not getting audio? Oh, because there isn't any right now. That's why. Okay, we're good. We'll just wait for court to begin. They're supposed to be back about 1:15. The jury's going to work on a couple things the jury's going to be back at 1:30. So they're probably going to address just a couple issues and hammer out the details of how the rest of the case is going to go before the jury comes back. Logger. Arose by any other name, right? Yeah. I like it. I mumbled no salad. The only reason I had to say I didn't have salad is because there were all the fixings for salad right there in the fridge. Even the avocados are ready. I just didn't. I don't have anything. I just didn't eat that. I just thought I'd rather get the Tupperware out of the way, clean out the fridge, make room for more good food, than eat the salad. All right. Why is it flashing like that? Grr. It says it's dropping frames. Like, look at this. See the strobe light? This should be staying red, not turning green. And this should not be flashing like it is. What have I done wrong? I'll let it play through and see if it worked. Cannot get on board with avocado. Oh, scent bunny. What about guac? You can do guac though, right? Everything is broken. Have you ever gone to the fridge so excited for some good leftovers only to find that someone else ate them? Yes. This is the story of my life. So sad when that happens. Yes. I've put pizza in the fridge because fridge pizza is really good. I'm a big fan. The day after pizza is fantastic out of the fridge, especially if you get like a combo pizza. Really, really good. And I've like purposefully packaged it up, put it in the fridge, and be like, I'm so excited for tomorrow where I get to eat the pizza. And then I run down there, and it's like one of my kids had like a urge for some food late night, came down, raided the fridge, and all the pizza's gone. Like, seriously. It's a recipe. I make it from scratch. I mean, start with browning the beef, and for mine I use I like Campbell's cream of chicken, sometimes cream of mushroom, but sometimes cream of chicken soup is the closest that's not from scratch. I do put a little sour cream in there, give it a little more, make it creamier. I think the secret ingredient is paprika. You have to add paprika. But yeah, it's yummy. It's all about the seasoning on the hamburger. That's what makes or breaks the stroganoff.
When are we going to break for lunch, Judge?
Fridge pizza for the win. Teresa, you have to buy a lot of pizza for there to be leftover pizza, but yes, you can do it. Put leftovers in a Greek yogurt container. Nobody touches that stuff. See, I didn't know there's a strategy to it. My problem was I was using clear wrap. Anyway. All right, we are due back in court. I'm just excited. We're reached the end of this case, and it's been good all throughout. It's been a good trial. I've loved the arguments. I've loved the courtroom defense and prosecution exchange. The judge has been great. I think our jury's been hopefully attentive, even though they're not allowed to take notes here. But we'll give them some time to deliberate and see what happens. This is funny, Kathy. That's funny because my son asked me to make the hamburger stroganoff because it was his birthday. That's why I made the hamburger stroganoff. It was his birthday dish. Ooh, fried onions. That is good. I haven't done fried onions in a stroganoff in a long time because my kids are not a big fan of onions. I sort of cook to their taste now. Next time, hide the pizza in the veggie bin. That's where all the broccoli is, which apparently can kill you. And don't eat broccoli if you're in like 19 states. Do I use Campbell's Friend or cream of chicken? I use the cream of. I like the cream of. Wogger, this is funny. Having worked at a couple businesses where there was a shared fridge and we had problems, we had people, there's always that one guy who thinks anything in the fridge is fair game, even if somebody just brought it that morning, and he'll eat his lunch early and then I don't know what happened. Yeah. That's where pranks come in really handy. And all the pranks you can have. We won't talk about them because it's just after lunch right now, but fun times. Last minute text messages from prosecution may have hurt the defense. We shall see. It was spicy, but it was just proving the financial crime. It did coincide very nicely with the time of his death, but it didn't. There was nothing in there that proved the murder. We have signs and a camera on our fridges at work. It's the most secure part of the building is the employee break fridge. Latest voting on the poll was 70% think that she has been proven guilty by the state, and about 30% say no. So, okay, I've got to figure out why this drive doesn't work. The benzos, that's the proof for you. Browchick, the benzos. He was allergic to benzos. He knew it. And she prepared his medications, right? So she drugs him with benzos, then injects him with insulin. A bowl of raw onions at dinner? Whoa. Are they like the little, like French onion, like the tiny things, or like a full-on white onion? Just eat it like an apple. Deliberation. That's going to be our next poll. We're going to do that as soon as closing arguments are done. I do that because the closing argument really wraps everything into a nice package. Where you hear all the evidence from one side or the other that's pertinent, put together in one deliverable to the jury, and it sort of lets you know if it's a simple cut and dry because you just get refreshed on everything you heard over the last couple of days. So we're going to do the poll at the end of closings about how long they'll deliberate. She had a script. I have a short somewhere. I spent instead of doing the sound effects that I was supposed to do last night, I spent time using this machine that's doing the flashing now, changing the settings, trying to see if I can bring the feed in via HDMI instead of SDI, and I switched from 1080p 59.94 to 1080p 60, and I thought that would improve it, but it's got a 10G connection. Well, no, it's actually got a 1 gig connection to a NAS drive, and it's having problems recording on the NAS drive, like it's too slow. But it's a solid state disk. I have issues. Are any quartz in 4K? Yes. Some of the pool media outlets, some of the companies that do pool media like Court TV have 4K equipment in the courtroom, but almost always the feed that is shared to the media is either 720 or 1080. The reason being 4K takes a lot of bandwidth to push live, and bandwidth is expensive. It costs a lot to push that. And so yeah. So you will see some in 4K, but it's usually been recorded live and then aired later. I didn't make an email command. Decided against it. Okay. Turn it off and on again. I would. It's in the middle of recording right now, so I'm trying to let it finish this too for a case. Then go back and see if it dropped frames. It can't be a space issue.
In front of the Walmart.
It can't be a space issue because I've got like 1 terabyte free. Okay. I have not done the Smarty Pants soundbite yet. I need to grab that.
I was kicked back, taking it easy.
Need to make a cog in Smarty Pants.
Are we going to address subject matter jurisdiction?
Bob, this one is not a sequestered jury. This one, they go home. The last one, they were sequestered. Thank you, Amber. Appreciate that. I just haven't got around to it. Breezy. Oh, you also want the bad girl? My client is a bad girl. That's what we need. Okay. Let's see. Frustrated with this recorder. I'm having tech troubles. I did just buy something to improve this. I bought new memory cards for it instead of using the NAS storage, which might work better, but then it makes it slower. It means I can't use the replay machine. Yeah. All right. Breezy, thank you very much for the super chat, by the way. Hear the song again. Mathis, let's see. Just checking where all the audio's routed. If my mouse will work, possibly. Make hay while the sun shines. That's when you want. All right, here we go, Mathis, just for you. Of course, Court will come back as soon as this happens. This is a song by Mathis from our last trial. That didn't work right. Mathis is not working well at all. Mathis, it doesn't want to play nicely. I've got to figure it out. I've got everything routed for audio for Court, which is using the same computer that I would have to play the song on right now. And so it's wanting to fight for the connection. Just got a message. Hang on, from Picky. Hang on one second. Hold tight. We found an issue where people are saying I can't chat in, I try to type it and it never shows up. Your messages never show up. And some of you have words in your username that are banned words. And if that's the case, it will never show up. But let's see here. Yes, so rethink your usernames. We're not going to let in. We're not going to let in bad names. Fanny back. If I was in the UK, you wouldn't be allowed in, but I'm not. So you're allowed in here. How many naughty words do we have? A lot. This is a funny story. I recently wanted to check and see what words were on my banned word list. So I exported the list of banned words from YouTube, and I put it in a notepad just so I could check to make sure there wasn't something that had been included inadvertently. So I've got it in a notepad. So it's just like a white screen with a list of bad words. And they're all bad words. Okay. They're all bad. Okay. I'm not going to, it's much more than 7. I would say closer to 60. Okay. And so it's sitting on my computer, and I open something else up, and I don't realize it's there. I'm sitting in church with my computer in a meeting, and I've got my laptop open, and I'm trying to pull something up and research it. And I close that window, and there's a guy sitting next to me, and he's looking over at my screen, and it's just like a list of all these bad words. Okay, it's just, I'm like, whoop, close that one down. I got caught. I got busted. He hasn't said anything, but I also haven't looked him in the face since that moment. So anyway, I thought you'd enjoy that. Yeah. Oh man. We'll see what happens next week. All right. Why did I leave it open on my computer? I mean, there's nothing. That's the worst thing on my computer. I don't have bad stuff on my computer. Where is this list? I don't share it with people. They're pretty bad. Amber can vouch. They're bad words. They're bad words. I scroll to the bottom and I get to the S section, and then it says, would you like to see 21 more words? And I say, yes, and I've got more. So there are a couple, I'll tell you this, there are a couple names that I put in there because we're a Pickles Not Politics channel. So if you try to post something that would clearly be in the realm of politics and not pickles, it would disappear. Anyway, yeah, the subject of next Sunday's sermon is, oh my goodness. Why would witch be on the banned list? Occasionally, we've added words to the list when there's a trial that seems to bring a particular response to people. And they're like, oh, this person is and they have a bad name that's not a swear word, but it's really not kind, really derogatory. Sometimes we'll temporarily add words like that, and sometimes we forget to take those words off. So there might be a word that in that particular trial setting is, we just deem is probably not appropriate for the conversation. Then we just forget to take it off. Like, for one thing, our mods are incredible, and they're really good at catching people who are in here just to stir up trouble. And so one of the words we have in the banned list is troll. And we do that because we don't need you guys calling out trolls. We don't want people to be like, oh, you're just a troll. That is one of the things that will devolve a chat faster than anything, is people back and forth calling out a troll. Even though they might be right, that conversation is terrible. It's terrible for chat. And so we ban the word troll. That's one of them. That's one of the few I can tell you. Okay. Let's see. So I'm trying to find... I will tell you, I have more banned people than I have banned words, because the mods do their jobs. Now you guys are trying to find the bad words. They're not going to come up. They won't. I don't know. Yeah, just 1 second here. We could have a naughty words page on Discord. No, I'm not gonna give out all the naughty words. There are some words I have on there for my own reasons, and some are to make Maud's life a little bit easier. Brand, do you think something's going down here? It's a little late for a plea deal. I do. You should ban the word goblins. Let's see. Nikki, rebuttals were good. We're spicy. We got from 116 to 130, so we got 14 new objections during the rebuttal, and there was just one witness, one investigator. It was pretty good. It was, I would consider that a mic drop moment for the prosecution, although it didn't really prove this case. It proved the other case. All right. Picky, our mods are looking at it. Hopefully. At least I sent it to them if they got time. Okay, what's the holdup? We're now 7 minutes past when the jury was supposed to come back in. They might be doing things off the record. Kathy, we do not know what we're waiting for right now. We're expecting closing arguments and jury instructions. Could just be something as simple as, fixing the jury instructions, but I thought those were done this morning. Artie Bay, it sounds like today would be a good day to just close your eyes and listen to court. Just let your eyes rest if they're dilated. Ricky, nope, you're not on the banned word list. I've gone through the list of banned accounts. Like, for instance, if you come in here,
I was kicked back, taking it easy.
Your username on YouTube is P Diddy, and your comments sound like something that was read in a the P. Diddy trial, you're going to be on the banned list, right? So P. Diddy is on the banned list. But for some reason, so is Celine Dion. And I don't know why. She came in here and said something. All these famous people coming in here stirring up trouble.
I'm not a camel.
Are you ignoring me and my anniversary message? No, I was just looking off the screen. I'll go back and catch up. Debbie Cook, member for 2 months. It's been longer, but I started on over a premium so RA could make more money. Thank you. Love being here. Best chat on the internet. Debbie, thank you. Lizzie Dog, member for 21 months. My grandpa used to always need a bowl of raw onions. Eat a bowl of raw onions at dinner. He'd eat them like nuts. Crazy. Breezy wants the bad girl sound effect. And Misconduct, member for 22 months. Getting closer to new courthouse. 2 months away, and the new one looks great.
What more do you need to see?
What more do you need to see? I have not created any of the new sound bites yet. Please add moist.
Zella install it as well.
It's not on the list.
Somebody just sent me a video of roaches fighting. I don't know who won.
Shame on you, sir. Because he's the guy. When are we going to break for lunch?
You know what's interesting? I've got a lot of the same account on here. Like somebody uses the same profile picture for all their troll accounts.
Scratch all
I've blocked the same person like 15 times. It's the same profile picture.
You're talking about stuff that is not relevant.
That's dedication. It's a lot of subscribes. You have to subscribe to be able to chat. So, late but present member for 11 months. Just eating king cake while impatiently waiting on court. Love to y'all. We're going to start. Okay, this is done recording. Let me see if it played properly. We could have watched the trial. We might still do it. No, as soon as I start, they're going to start court. I know it. Let me back up here. Let's go.
I think I'm about to catch a whooping.
I think you are as well. Melissa Webb, congratulations on 10 months. I'm addicted to pickles now. Bought a jar of Clausen's last night, and now I'm in pickle heaven. Box source 2 is going to be 2.
Are we going to address subject matter
Which one looks better?
jurisdiction?
3.
You're talking about stuff
I think
that
the
is
resolution's
not
higher
relevant.
right here.
In front of the Walmart.
See the flag tassel? I mean, it's brighter on this one, but the clarity is just so much better right here.
Because he's the guy.
I was kicked back, taking it easy.
Okay. I just handed out IT number. See if we can get that. What trial are we covering next? I don't know yet. We've got one from Thurston, Washington, which we'll cover in the break. We could have covered right now. I sort of wish we had. Let me pull it up.
I'm not a cat.
Pull this up. I dropped 2,033 frames. How did I drop 2,033 frames? Tech Twubbles.
Have them send someone with more experience.
Okay. Court's taking forever. We're gonna just go ahead and watch something else. That's what we're gonna do. You guys okay with that? I'll keep the audio on from this court, but we're going to also bring in the audio from this court right here, which is Thurston County. And let's play. We've got a little trial here where this guy with the blue background, he has to answer some questions to the judge, and the girl who's about to come online, she's asking for a restraining order against him.
Ms. Berglund, if you would activate your video, please.
There she is.
Thank you. If you would both raise your right hands for me.
I've got to move to a different corner.
Swear the testimony in this case will be the truth, whole truth, and nothing but the truth.
Yes, Your Honor.
Mr. Ionescu, I need to hear from you.
Yes, Your Honor.
Thank you.
He's got a nice setup. He's got a Rode mic. It's a shotgun mic on a boom arm, which is interesting. But it's a good mic. Good sound. Using the blue screen instead of the green screen, which is just a preference issue. I could not because I use too many blue shirts. No. Just like that.
All right.
Have to pause for a second.
Have you received a copy of the court's charge? Here it is.
We're going to switch back over just 1 second.
And I've realized that one thing we failed to discuss was the jury verdict form. We have one, but I don't know that it's been approved by the other side.
They had it.
Now we're back. I knew as soon as we started something else would work. I should have started a long time ago.
It's pretty simple and straightforward.
I think it's under $100 for the mic.
Thank you for the list, Angie. Thank you so much.
We're about to closings. They just need to go over the verdict form. This will solidify whether we get any lesser includeds. Pretty simple form.
Bring the jury.
The judge is humming.
All right. Is this the same version you submitted earlier, or is it a revised version?
The one submitted this morning is that one. The original one I submitted a couple weeks ago was that one has been revised. But this one has been approved by the. It includes the lesser included.
Okay, I'm going to have.
Does have lesser included.
You may have to take it in the other office to staple it.
Your Honor?
Yes.
I have a minor point to discuss. May we approach? Well, since the jury isn't here.
Not here.
I was looking over the identification of the state's exhibits and the defendant's exhibits, and I believe there's might be a little confusion or clerical error in item number 10 and item 16. It reads an empty vial of methylprednisolone acetate injection. It's not the injection itself. It should read empty vial of injectable methylprednisolone acetate.
Okay.
I took that right off the label.
She said she took it right off the label.
Did he just give us the bird? Do you guys see that?
Fine. It's a minor point anyway.
Okay.
Fine.
All right. Can the defense approve the court's charge?
Final stages.
Okay.
You guys saw. He gave the finger, right?
Oh, yeah.
Defense leaves their mics off. Just a strategic move so they don't get caught saying something on mic that they don't want to have go out.
Okay. Check this. I think this is an older version. I don't think that's the most recent one. I think this is the most recent one. You don't want to get confused.
The lawyer who stood up and was talking, he just pushed his glasses up on his face with his middle finger. That's all.
All right, let me ask counsel, how much time do you require or request for argument?
Your Honor, we'll defer to the defense.
I don't know. The state has the burden of proof. Maybe the state can.
10 minutes each?
20 minutes?
Are we talking half an hour? Are we talking
Half an hour?
What do you guys need?
No, I don't.
You would stand. Oh, good. I thought you said 40 minutes here.
Hey, want to do that 45
Okay,
minutes?
45 minutes.
45 minutes?
Yes, Your Honor.
Okay. Will you be doing the closing, Ms. Akert?
Yes, I will, Your Honor.
Okay, how do you want to divide your time?
Going to bifurcate?
30 and 10. 30 and 15. We get executive.
What?
We have 40?
35-10.
35 for closing and 10 for rebuttal, Your Honor.
Do you want a discreet 1-minute warning
I would appreciate
just
that, Your
an air
Honor. Thank
horn
you.
will work. Just
on both ends?
like a hockey buzzer.
That would give the defense the full 45 minutes if you wish to take it. Do you wish a 1-minute warning, 2 minutes, or what? This is
2-minute warning is fine.
Pardon?
2-minute warning is fine.
2
Your
minutes.
Honor.
Mr. Victor is going to be doing the closing for the defense.
All right, here's the final question I have for you. It's going to take me a little while to read these instructions because it's 18 pages. Do you want to take a brief recess between the court charge and the closing arguments, or do you wish to go on through? It's up to you.
Judge, the only thing about the instructions, I thought we were placing the involuntary manslaughter before the instructions dealing with malice.
I thought that's what we did.
Yeah, I thought so too, but it's not the case.
Judge, I think that is what we
Proposed.
Okay.
It would just be a matter of cutting and pasting page 10 where it starts with the definition and moving it before the discussion of malice on page 9.
Okay. I'm going to ask you two to go with Ms. Brown Bailey and assist her so that you can set it forth appropriately.
kids are not back in court. Her kids. Don't see how it could be involuntary. I agree. I can see negligent. I can see negligent homicide as being an option, but those backseat drivers when you're typing. Terrible. She's talking to her mom, who's seated behind her.
Oh, okay. Oh, okay. Yes, very legible. Thank you. Even better than typewritten.
At the end of the day, she is going back to prison, regardless of this verdict as she's serving. I think still in the front end of an 11-year sentence for the Ponzi scheme. Yeah, it seems like nobody was safe. Friends and family all were targets in this Ponzi scheme. But I don't think they sat to, I don't even think that she thought, I'm going to develop this Ponzi scheme where we can get a whole bunch of money. I think in her head, she had a business idea that she thought would work, that was good. She was going to cash in on these government contracts. Being a woman-owned business, it gives you an advantage. Being local, you might be from West Virginia. It has, they have different economically disadvantaged areas where she might have been operating out of, which will give you another bonus. A small business from that area. There are all these things that basically boost your bid before the government even looks at the price on the bid. And so, if all things being equal, if you can buy things at the same cost as everyone else, you having those advantages would mean you'd win the contract over some other business. So I'm sure she thought she would be winning, and she thought we could win these. And it seems like she was always trying to do that. But she sold the idea and took profits personally to pay for their expenses. And then the money never came in. It's not as easy as just, signing up on a website and then winning government contracts. I think it developed into a Ponzi scheme because the business model didn't pan out. We got a spam call. Hello? Hello?
Hello?
Hello?
Hey, good morning. Amanda here. I'm giving you a quick...
I don't talk to computers. She faked the government contract. I thought she had one at a state level that actually did pay off. Didn't they have one state level contract? Amanda, I'm not a robot. The Ponzi scheme was basically, she would tell her friends, there is a government contract out there that we are bidding on. So we're basically, the government is saying, we want this work or this service or this item procured. We need this, whatever task it is in the contract. This is what we want to have happen. And we want all you companies out there who are interested in doing this and who can meet our requirements to tell us how much it's going to cost. And so they all bid on it. They say, I can do it for $10. I can do it for $15. I can do it for $20. And the government says, we'll go with the $10. That was the lowest bidder. But it's not that simple. They also first look at how many preference points do you have? Is this a veteran-owned company? Is it a woman-owned company? Is it disadvantaged? Is it a small business? And there are all these rules that the federal government in their bidding process has to follow to say, if all things being equal, you know, bidder A has more preference points, you have to go with them. Hey, Angie. So the government spends boatloads of money. Anything you could possibly think of. We need sandbags for hurricane, flooding preparation. So set a bid out. Who's going to provide sandbags at the best cost for us? And companies can go out and look at these list of contracts and filter through which ones they want and say, we want to bid on that one and that one and that one. And then they'll submit a bid following this process. It's a lot of paperwork, and I would say it's a mountain of paperwork and a lot of policy and procedure and jumping through hoops. But at the end of the day, if you win a contract, they can be very lucrative. I worked for a lot of contracting companies in my time working for the federal government. And to give you an idea, the first company I worked for was a small Native American owned company because the owner had 51% or something Native American blood in him, and it was just like 3 people in an office that rented a little tiny space on a strip mall and sort of hired from their friends. Okay, that's what it was. But they hired and filled these IT contracts for the government. And so the government says, you won this many positions, and now just bring the people in. And they bring the people in. They made so much money. The first year that they were in business, before I joined them, the first year I was in business, almost every employee got like a massive flat screens TV at the company party at the end of the year because the owners just felt guilty about how much profit was left over. Okay, they were giving away they're giving away cruises, they're giving away all this stuff because there was so much money in it. Turns out it wasn't always flush like that. I joined right after that, where they've got a lot more conservative, and I don't think I ever won anything. But there was a lot of money there. And so she's looking at these contracts and saying, hey, there's a lot of money in providing goods and services for the federal government. And that's what she was going for. I never won a TV. Wait, I did win. I've won a TV one time. I think it's in the other room. I won it at a Las Vegas roofing convention where I was a salesperson. We were presenting, and I put my name in a fishbowl, and they drew my business card out. And then they didn't want to give it to me because I was there with an exhibitor. But it was a 720p HD television, and I think it was a 21-inch. So I have won a TV. I take it back. Why is my wife calling you? I don't know. Why is she using a computer to call me? Not at a flashing convention. Flashings are involved in roofing, but roofing convention. Metal roof and wall systems. Flashings are just, the flashing is the extra pieces around the edges and corners. That's what we call flashing. That's why you have warrants in Vegas. I technically do have devices that are televisions. I just don't have an antenna for them or cable, so they don't receive a signal.
My review of the court's charge, I see that we have switched the elements for involuntary manslaughter with the definitions of malice. Is that correct, counsel?
Correct, Your Honor.
Yes, Your Honor.
And we haven't changed the wording of anything. We've simply moved those segments around as indicated.
It was a cut and paste. Yes, sir.
Yes, Your Honor.
All right. That's agreeable, certainly, with the court. That's what we discussed. One more thing. Do either of you wish to have the podium set up in front of the jury box?
Yes, Your Honor.
All right. I'll ask the bailiff to do that, please.
And Your Honor, while we're doing that, after some reflection, I'm thinking I might need a little more time for closing. If we could have an hour total, I won't need that long, but I think mine will probably run about 45 minutes on its own.
All right. So you'd like to have an hour altogether?
Yes, Your Honor.
And how do you want to divide that?
45 and 15.
Sure.
45 and 15, Your Honor.
You still would like to have the 1 minute warning?
Yes, please.
And that would afford to Mr. Victor a full 60 minutes. Is that agreeable?
Yes, sir.
With the 2 minute warning?
Yes, sir.
Good. So 2 hours of closings.
All right. Are we ready for the jury?
What could possibly go wrong?
Yes, sir.
Bring in the jury, please.
And Your Honor, the state does think that it would be appropriate to take a break between the charge and beginning the closings, given the length of the closings.
Okay. I think that's probably a good idea.
Bring the jury.
We're going to keep the objection counter up. I think there's still going to be objections on this one. I think they only stand up when the jury actually starts walking in. And the cameras tend to cut to the flag when that happens. Nope, she's not standing up for him. I don't know why.
Members of the jury, the next phase or stage of this case, as I touched on earlier, is the instruction of the law by the court. I can tell you that this is a very boring and tedious part of any trial, and perhaps some of you who have served as jurors before know that very fact. Sadly, you must pay strict attention to what I tell you. Your oath requires you to apply the law that I will state to you to the facts you determine from the evidence. So this is a very important stage or part of any trial. Members of the jury, you have now heard and seen all of the evidence in this case. You are the sole judges of that evidence and the facts that it establishes. It is your sworn duty to determine and base your verdict only upon that evidence. In doing so, do not be influenced by sympathy, anger, passion, prejudice, or public sentiment. It is now my duty to inform you about the law that applies to this case. You have no right or privilege to disregard these instructions or to form a different opinion about what the applicable law is or should be. All of these instructions are important. Do not pick out one part and ignore other parts. You are to draw no inference from the order or manner in which they are given, and they are to be considered by you in their entirety as a whole. The indictment in this case is merely an accusation, and it is not any evidence of guilt. The burden is on the state to prove the guilt of the defendant beyond a reasonable doubt. The defendant is not required to prove her innocence. Our law presumes a defendant to be innocent of crime. So the defendant, although accused, begins the trial with a clean slate with no evidence against her. and the law permits nothing but legal evidence to be considered in support of any accusation. So you see, the presumption of innocence alone is sufficient to acquit the defendant. You must determine the facts of this case from the evidence only, that is, from the testimony of witnesses and exhibits. Disregard completely testimony to which an objection was sustained or exhibits ordered stricken out of the record. Absolutely nothing that I have said or done during this trial is to be considered by you as evidence or as any indication of an opinion concerning the weight of the evidence, the credibility of the witnesses, or the guilt or innocence of this defendant.
I got Kathy
Nothing
back.
that I, as judge, said or did at any time during this trial is to be considered by you as evidence of any fact or as an indication of any opinion as to any fact or evidence, or as a measure of the credibility or truthfulness of any witness who testified, or as to the weight you should give to such testimony, or as to what your verdict should be in this case. For you are the sole judges of such matters, and I am only the judge as to the applicable law. The evidence from which you are to determine and base your verdict consists of the sworn testimony of all of the witnesses, regardless of which side called them as witnesses and whether their testimony occurred on direct or cross-examination. The exhibits that were received into evidence, regardless of who introduced them into evidence. Any facts which I have told you were agreed upon by stipulation or otherwise, and any fact which I took judicial notice of. However, if you do not agree with that fact, you are not bound to accept it. Members of the jury, there are two basic kinds of evidence, direct and circumstantial.
Not bound to accept
direct
judicial
evidence
notice.
is testimony as to what a witness saw, heard, or did. Circumstantial evidence is indirect evidence, that is, it is the evidence of a fact from which another fact, not directly testified about, can be inferred or found. Both of these kinds of evidence may be considered, and it is for you to determine and decide whether or not a fact has been proven by circumstantial evidence by considering all of the evidence in light of reason, common sense, and experience. There is no quantitative difference between direct and circumstantial evidence. The following elements are not evidence, ladies and gentlemen, and you are not to consider them as evidence for any purpose whatsoever. Anything that any of you have seen or heard outside of the courtroom or when court was not in session. Do not consider or be influenced by any testimony or evidence which has been excluded and not put into evidence, and do not consider or be influenced by any testimony, evidence, or any other fact or subject that I instructed you to disregard and not to consider as evidence. If during the trial I instructed you to consider certain testimony, evidence, or facts only for a particular or limited purpose, you are to continue to do so, and must consider such matters only in that manner and for that limited purpose. Do not be influenced by or draw any inference from any objections that were made by the lawyers during this trial, or my rulings upon such objections, for such matters are not evidence. As I have explained to you throughout this trial, statements or arguments made by the lawyers are not evidence and are not to be considered by you as evidence, for the lawyers were not and are not witnesses. What they said to you in their opening statements, or what they will say to you in their final closing arguments, or at other times, were and are made to aid you in following, determining, and interpreting the evidence as it relates to the issues before you and their respective sides of this case. While you must carefully consider the testimony of each and every witness and not disregard or overlook any testimony, witness, or evidence, the jury is the final judge of the credibility of the witnesses and the weight of the evidence. The number of witnesses testifying on one side or the other of an issue is not the only test of weight and credibility. If you feel that the evidence justifies it, you may believe one witness over a number of witnesses testifying differently. The test is how truthful is the witness and how convincing is the testimony in light of all of the evidence and circumstances shown. As jurors, you are also entitled to draw reasonable inferences and make reasonable deductions from any of the testimony or other evidence as you come to believe are justified in the light of reason, common sense, and experience. If you come to believe that any witness did not tell the truth about any material fact after carefully weighing and considering such testimony, you may disregard it, or any part of it, or give to it, or to any part of it, such weight and credit you determine it deserves. In weighing and crediting the testimony of any witness, you may consider the good or bad memory of the witness, the interest of the witness in the outcome of the trial, the relationship of the witness to the parties involved in the case or to other witnesses, the attitude and manner of testifying of the witness, the opportunity and means or the lack of opportunity and means of the witness to learn and to have knowledge of the matters about which he or she have testified, the reasonableness or unreasonableness of the testimony of the witness, the intelligence of the witness, the appearance of bias or hostility or friendliness or unfriendliness of the witness to the parties involved in the case or to any other witness, and any contradictory acts or statements of any witness that you determine were done or made that served to contradict the testimony of such witness in court. From all such factors and considerations that appear from all the evidence and circumstances shown in the case, you are to evaluate the testimony of all of the witnesses and the weight to be given to their testimony and determine the credit you believe it is entitled to receive. In this case, you have heard testimony by witnesses who are presented as experts, who by knowledge, skill, experience, training, or education had acquired scientific, technical, or specialized knowledge in the field or area about which he or she has testified. As an expert, he or she is therefore entitled to express an opinion upon matters within his or her field or specialized knowledge and to state the reasons for an opinion. Expert testimony is to be considered and evaluated as you would the testimony of any other witness. You may accept or reject it in whole or in part, or give to it or any part of it such credit and weight you come to believe it deserves. In evaluating expert testimony, you should consider the knowledge, skill, experience, training, and education of the expert and the basis and reasons given for his or her opinion in light of all other testimony and evidence in this case. The court instructs the jury that evidence of other crimes, wrongs, or of acts by the accused is not to be considered to prove her character in order to show that she acted in conformity therewith. However, the jury may consider such evidence for other purposes, such as proof of motive, opportunity, intent, preparation, plan, identity, and absence of mistake or accident as to the crimes charged. This court has taken judicial notice of court documents generated by the United States District Court, Southern District of West Virginia. That is, the court has taken as fact that the litigation in the United States District Court, Southern District of West Virginia, occurred based upon the determination of sources whose accuracy cannot reasonably be questioned. You are instructed, however, that you may or may not accept that fact as conclusive. The offense charged in the indictment in this case is murder of the first degree. You may return one of two verdicts pertaining to murder of the first degree under the indictment. They are 1, guilty, and 2, not guilty. Murder of the first degree is any felonious, willful, malicious, deliberate, premeditated killing of another person. Murder of the first degree consists of an intentional, deliberate, and premeditated killing which means that the killing is done after a period of time for prior consideration. The duration of that period cannot be arbitrarily fixed. The time in which to form a deliberate and premeditated design varies as the minds and temperaments of people differ and according to the circumstances in which they may be placed. Any interval of time between the forming of the intent to kill and the execution of that intent, which is of sufficient duration for the defendant to be fully conscious of what she intended, is sufficient to prove a deliberate and premeditated killing and to support a conviction for first-degree murder. Before the defendant can be convicted of murder of the first degree, the state of West Virginia must prove to the satisfaction of the jury beyond a reasonable doubt that 1. The defendant Natalie Page Cochran, 2. In Raleigh County, West Virginia, 3. On or about the 11th day of February 2019, 4. Feloniously, willfully, maliciously, deliberately, and unlawfully and premeditatedly slayed, killed, and murdered 5. Michael Cochran. After impartially considering, weighing, and comparing all of the evidence, if the jury and each member of the jury is convinced beyond a reasonable doubt of the truth of the charge as to each of these elements of murder of the first degree, you may find Natalie Page Cochran guilty of murder of the first degree as charged in the indictment. If the jury and each member of the jury has a reasonable doubt of the truth of the charge as to any one or more of the elements of murder of the first degree, you shall find the defendant Natalie Page Cochran not guilty. Involuntary manslaughter is committed when a person caused the unintentional death of another person. This court instructs the jury that the absence of an intention to kill or to commit any unlawful act which might reasonably produce death or great bodily harm is the main element of involuntary manslaughter. A person is guilty of involuntary manslaughter when a person commits an act in a reckless or grossly negligent manner and unintentionally causes the death of another person. Therefore, in order to find the defendant Natalie Page Cochran guilty of the offense of involuntary manslaughter, the state of West Virginia must overcome the presumption of innocence and prove beyond a reasonable doubt each and every one of the following elements. 1. That the defendant Natalie Page Cochran, 2, on the 11th day of February 2019, 3, in Raleigh County, West Virginia, 4, unintentionally, 5, caused the death, 6, of Michael Cochran, and 7, against the peace and dignity of the state. If each and every juror is not convinced beyond a reasonable doubt that the state of West Virginia proved beyond a reasonable doubt each and every element of the offense of involuntary manslaughter, the jury must find the defendant Natalie Page Cochran not guilty. Malice is a subjective state of mind of the defendant. It may be proven by evidence of circumstances surrounding the crime, such as words or conduct of the defendant before, during, and after the event, or evidence of ill will or a source of antagonism between the defendant and the deceased. Also, malice may be inferred from a deliberate cruel act, indicating a heart disregarding social duty and fatally bent on mischief. Malice and intent also may be inferred from the defendant's intentional use of a deadly weapon under circumstances which the jury does not believe gave her legal excuse, justification, or provocation for such conduct. Malice may be expressed to include not only anger, hatred, and revenge, but other unjustifiable motives. It may be inferred by you from all of the evidence in this case if you find such inferences reasonable from the facts and circumstances in this case which have been proven to your satisfaction beyond a reasonable doubt. Malice may be also inferred from any deliberate and cruel act done by the defendant without any reasonable provocation or excuse, however sudden. Malice is not confined to ill will toward any one particular person, but malice is every evil design in general. It is not necessary that malice must have existed for any particular length of time, and it may first exist at the time of the killing or at any previous time. As a defendant is presumed innocent of the charges brought against her, she does not have to prove herself innocent and is not required to call any witness or produce any evidence. She is also not required to take the witness stand and testify, for she has a constitutional right not to do so. The fact that the defendant did not testify is not any evidence against her, and you shall not consider that she did not testify or draw any inference from that fact as to the guilt or innocence of the charges brought against her. You must entirely disregard it and not discuss it. The court reminds the jury that throughout this trial, the state maintains the burden of proving the defendant's guilt of the crimes charged beyond a reasonable doubt. From time to time during this trial, it was necessary for me to talk with the attorneys out of the hearing of the jury, whether by having a conference at the bench when the jury is present in the courtroom or by calling a recess. Most of these conferences involve determinations as to whether evidence is admissible under the rules of evidence. It is appropriate to take these matters up outside the presence of the jury. If I concluded that a more prolonged discussion was necessary, I may have excused you from the courtroom. You have heard evidence concerning alleged conduct or other acts of the defendant, Natalie Page Cochran, which are not charged in the indictment. You are instructed that such evidence is not admitted as proof of the defendant's guilt on the present charges. This evidence is admitted for a limited purpose only, and it may be considered by you in deciding whether a given issue or element relevant to the present charge has been proven. Accordingly, this evidence may be considered by you only for the limited purpose for which it has been admitted. In this instance, the evidence of the defendant, Natalie Page Cochran, alleged criminal acts of the, quote, Ponzi scheme, unquote, may be considered only for the purpose of determining whether the state of West Virginia has established the motive to perpetuate the first-degree murder. You are instructed that upon the trial of this case, if reasonable doubt of any fact necessary to establish the guilt of Natalie Page Cochran, the defendant, as charged in the indictment, be raised by the evidence or lack of evidence, such doubt is decisive and the jury must acquit the defendant, Natalie Page Cochran. You do not have to believe that the defendant, Natalie Page Cochran, is innocent of the charges against her in order to find a verdict of not guilty. Your verdict of not guilty only means that the state of West Virginia has failed to prove to you the guilt of the defendant, Natalie Page Cochran, beyond a reasonable doubt. The jury is instructed that the mere presence of the defendant at the place of the alleged crime or crimes does not in and of itself indicate participation of the defendant in the criminal act or acts. The defendant's mere presence at the scene of a crime or mere knowledge that a crime is being committed is not sufficient to establish that the defendant committed the crime charged in the indictment unless you find that the defendant was a participant and not merely a knowing spectator. The state of West Virginia must demonstrate to the jury beyond a reasonable doubt a nexus between the defendant's presence at the scene of the crime or crimes at the time or times of the alleged crime or crimes and her participation in the criminal act or acts. In relation to any and all charges contained in the indictment in this case, if each and every member of the jury is not convinced beyond a reasonable doubt as to each and every element of the offenses charged, the jury must find the defendant not guilty. If the jury has a reasonable doubt as to the grade of the offense of which the defendant, Natalie Page Cochran, may be guilty, The jury shall resolve that doubt in favor of the defendant, Natalie Page Cochran, and find her guilty of the lower grade. If the jury has a reasonable doubt as to whether the defendant, Natalie Page Cochran, is guilty of any offense, the jury must resolve that doubt in favor of the defendant, Natalie Page Cochran, and find the defendant not guilty. Evidence relating to any statement alleged to have been made by the defendant, Natalie Page Cochran, outside the court and after a crime has been committed should be considered by the jury with caution and weighed with great care. All such statements should be disregarded entirely unless the other evidence in the case convinces the jury beyond a reasonable doubt that the statement was made knowingly and voluntarily. In determining whether any alleged statement alleged to have been made by the defendant, Natalie Page Cochran, outside of court after a crime has been committed was knowingly and voluntarily made, the jury should consider the age, training, education, occupation, and physical and mental condition of the defendant, Natalie Page Cochran, and all other circumstances surrounding the making of the alleged statement. The jury may give the statement such weight as the jury finds it deserves under the circumstances. The test for the burden of proof in a criminal case is beyond a reasonable doubt. This means that after considering all of the evidence, if you have a reasonable doubt of the accused's guilt, then you must find her not guilty. You must always remember there is no burden upon an accused to prove anything. It is the state who has the burden to prove the accused's guilt. One never has to prove one's innocence. You must give an accused person the benefit of any reasonable doubt you may have from the evidence or from the lack of evidence, but remember the doubt must be a reasonable one. This means that it must be founded on reason and should be explainable, not a dreamed up or fancied one with no basis. The test is not beyond a shadow of a doubt, nor beyond all possible doubt. It is beyond reasonable doubt. After hearing and considering all of the evidence, you are satisfied that based upon the evidence you have in your heart an abiding conviction of the truth of the charge, then you are convinced beyond a reasonable doubt. It is your duty in this case to apply the law as given to you as a whole in the form of these instructions to all of the evidence in this case. In that regard, the court has instructed you on your role in determining the credibility of a witness and the weight of the evidence. The court has instructed you on the difference between direct evidence of a fact to be proven and circumstantial evidence of a fact to be proven. You must never convict a person unless the facts justify it, but you should not shirk your duty when the facts do justify a conviction. You must require that the state meet its burden of proof, but you must not make the state's burden an impossible one. The burden is always on the state to prove guilt beyond a reasonable doubt. This burden never shifts to the defendant, for the law never imposes upon a defendant in a criminal case the duty of calling any witnesses or producing any evidence. A defendant is never to be convicted upon mere suspicion or conjecture. To convict, you must be satisfied beyond a reasonable doubt of the defendant's guilt after careful and impartial consideration of all the evidence in the case. So if the jury has, after a careful and impartial consideration of all of the evidence, a reasonable doubt that the defendant is guilty of the charges, it must acquit. If the jury views the evidence in the case as reasonably permitting either of two conclusions, one of innocence and the other of guilt, the jury should, of course, adopt the conclusion of innocence. In the trial of a criminal case by a jury, the law contemplates the concurrence of 12 minds and any verdict returned, whether guilty or not guilty. Each individual juror must be satisfied beyond a reasonable doubt of the defendant's guilt before he or she can consent to a verdict of guilty. If each and every individual juror has a reasonable doubt of the defendant's guilt, you must return a verdict of not guilty. The jury is no place for unreasonable pride of opinion or for stubbornness. While no juror should yield a conscientious opinion deliberately formed after a full and fair investigation of the case, nevertheless, it is the duty of every juror to consider all of the evidence of the case, the instructions of the court, the arguments of counsel, and to discuss the evidence with the other jurors with an open mind and to give careful consideration of the views of fellow jurors, and if it can be done without sacrificing conscientious conviction, agree upon a verdict. Ladies and gentlemen, that concludes the reading to you of the court's charge or the instructions of the law. We're going to take a very brief recess so that the attorneys can collect their thoughts, and you will hear shortly from them in terms of their closing remarks or closing argument. I warn you, we are not yet to the deliberation phase of this case. After the lawyers deliver their closing arguments, you'll be able to fully and fairly deliberate on this case. But at this juncture, you cannot discuss the case among yourselves or with anyone else. I contemplate perhaps a 5-minute break, and you will return to the courtroom and we will proceed with closing remarks. You may go with the bailiff now briefly to your jury room.
Okay, we are about to have closings in about 5 minutes. The judge spoke for 27 minutes, about 27:30 actually, giving instructions. So it wasn't the longest instructions, but it also was not short. I actually liked them. The way that the instructions are worded in West Virginia is very clear to me. I think it's there are definitely states that have a lot more legalese in their jury instructions than West Virginia's.
Break for 5 minutes.
Oh, apparently somebody's headed to the bathroom. You got 5 minutes. 5 minutes. Took a long time. The judge did a good job. Very clear. So we know we have two options. Well, I guess three options for the jury. There's going to be a not guilty across the board, which applies for both of the potential charges they can find guilt for. The first one is murder in the first degree, and the second is involuntary manslaughter. The difference between the two is primarily the intentionalness of the act. And I don't know how you can get to involuntary manslaughter. Negligent homicide is much easier for me. Involuntary manslaughter means that she just didn't know what she was doing. She's a pharmacist. If you find that she killed him, if you find that he died because of her actions, injecting insulin into Michael, how can you say that was involuntary? I don't know. It boggles my mind to think that somebody might find this. Anyway. We'll see. Why didn't she stand for the jury? Apparently, I remember the judge saying something about, we'll tell them why you're not standing or something at the very beginning of the trial. Apparently, he's the only one that stands. He's like, I stand for the jury. You guys stay sitting and seated. Which is good for me because it's a lot quieter in the courtroom. And you don't get that herd of elephants sound every time the jury comes in and comes out. The banker wrote a victim statement for her Ponzi trial. Said this woman goes around town not acting like she did anything wrong by stealing all that money. Yeah, she was a pharmacist by profession, and she was a specialist in the area of diabetes. So, I mean, insulin was her bread and butter, so to speak. It was her husband's downfall, but you guys are giving me a hard time. I opened one inappropriate document in the middle of the church, and you guys just won't let it slide. I don't know why I even had it still saved. I do remember why. see, somebody has a question about government contracts. Okay. A little behind the live stream, we got a question about government contracts. Sounds like the contracts were for durable goods. How would Michael not have been aware that their company was not actually purchasing any goods to fulfill these contracts? Am I correct that the profit would be the difference between what they paid for these goods and the government contract price? Yes. Michael was the businessman, not Natalie. Yes, you're 100% correct. But a lot of those orders are fulfilled with middlemen. You don't just say the government needs, I don't know, needs Beretta 9mm pistols. Okay, there was a time where I think they did carry they used like the Beretta 92. Oh, it's a spam call. Hang on. Just because you have a $239 million contract does not mean you made $230 million profit. Hello? Hello, Amanda? Hello? Didn't work. I tried. The contract amount is the total amount the government pays. The profit amount is the difference between your cost of providing those goods or services and what the government paid. So you might have a $239 million contract and your profit amount is $1.5 million. So it could be very narrow. Tash, the state did not prove insulin poison for any kind of poisoning. This case should not have been brought to court. I believe she knocked him out with the sedative, then used the insulin. Warrior Queen, I would have felt a lot better knowing that the insulin was tested. I want to go back to the facts about when they got the insulin from her fridge. Was it like months later? Was it weeks later? Was it that day? When did they get the insulin from her fridge? And I wish they had not just tested it. I'm pretty certain it's insulin. I can believe it's insulin, okay? But how much was supposed to be in there and how much was missing? And is the amount that was missing enough to have produced the result in Michael that they say occurred? I wish we had those. And why in the world would the FBI lab test substances without measuring them? Michelle B., those texts, the timing on them was remarkable. Yeah, leading right up to 2 days before. It was 3 months later, and the substance was insulin. Okay, I know it was insulin, but why did they not measure how much was in it? That's a very precise amount of insulin that's in these bottles. If it was full, I mean, just argue for the sake of argument, Andrea, if it was full, what would that do to the story? It would indicate that at least that wasn't used, right? Then you'd have to say we believe there was some other insulin that she got at some other point. There may have been a vial that was disposed of that we didn't know about. What if she just swapped his anabolic for insulin? I don't think there was any indication that he was injecting anything, was there? The kids said that it happened, but they didn't see any puncture marks. I realize insulin needles are tiny. Burner phone's going nuts. No testimony of how much insulin it would have taken. That was a tough question because every situation is a little different. Vial was collected in June after his death in... Oops. Whoa. Don't need that. Just opened Twitter on accident. Now I lost the message. After his death in February, so February, March, April, May, June, 4 months later, they get the vial. Why would she keep it? I mean, if she did it, if she used insulin to kill him, why would she keep it in the fridge? Doesn't that sort of speak to her not being not guilty?
All right. Are there any matters that we need to raise and discuss out of the presence of the jury at this time?
There's one that's been brought up by the defense, Your Honor, and that is the indictment says February 6th. The
indictment actually says February the 11th.
That's what I thought it said, too, but I was told by the defendant, and I didn't have a copy.
Well, I've got a copy because I heard the same suggestion that you did, and it says on or about the 11th day of February, 2019.
Blaine Selden, he came up with that.
Just the point I brought up, and it's probably too late to address it. The murder says February 11th. The alleged act occurred on February 6th. That's when the alleged act occurred. The death of Cochran occurred on February 11th. I don't know what we can do about it or anything of that nature.
It's on or about. There's nothing to do about it.
I don't think there is anything we can. Oh, we didn't have a court reporter.
Well,
I thought you were down there, Joanne. I'm sorry.
No, you didn't do anything wrong.
You didn't do anything
wrong.
wrong.
In the bathroom. Sorry.
All right. I think we can go forward. We can change the instructions, and I can read them all over again. But everybody's moaning and groaning, and nobody wants to hear that.
With a big sign that says, "This is Selden's fault."
Right.
Just for the sake of the record, I brought to the court's attention the indictment says that the murder occurred on or about February 11th. I just brought to the attention of the court the alleged act occurred on February 6th. The passing of the deceased occurred on February 11th. I don't know how that impacts anything.
I don't think it impacts anything. It's on or about. No objection was raised. You all approved the jury charge, and we're going forward.
Thank you.
All right. Are you folks ready to deliver your closing remarks?
Yes, Your Honor.
Bring in the jury, please.
You will bring the jury.
All right. Assuming we get all the closing statements in one big window, one big section, this is the last time the jury will be brought in until they're in charge of the show, where they decide what happens. So, let's see. I've seen that be a much bigger issue, getting the date wrong in other cases. Yep. Like mistrial type issue.
All right, ladies and gentlemen of the jury, as I have alluded to, the next stage or part of this case is the final argument of counsel. You will hear from each side, and the attorneys will argue the issues and the evidence presented, giving you their own interpretation of that evidence. As I've said over and over, their remarks would not be evidence themselves, but all of these attorneys have worked very hard in presenting this case before you, and I ask you to please give them due consideration. We will follow the same order that we have established in this case. As you know, the state does have the burden of proof, and we'll go forward first. Then the defense will present their entire argument, and the state has a brief period to rebut. All right, Ms. Acord, you may proceed.
afternoon, ladies and gentlemen of the jury. As you know by now, my name is Ashley Akerd. I'm an assistant prosecuting attorney here in Raleigh County. I've been presenting this case to you with Tom Truman, who is our current prosecuting attorney. We're here in the matter of State of West Virginia versus Natalie Page Cochran. And if you all will bear with me, I will have to do some reading as we go. There's a lot of ground to cover here. So the first thing I want to do is thank you for being here. Just very briefly, I know everyone does this, but this has been a long couple of weeks and we've had a lot of evidence come in this case. So just thank you all for sitting through it with us. Thank you for being here and thank you for deciding this case.
That's presumptive.
Now at this point, you all know why we're here and what we've been doing for the last few weeks. My job today is to prove to you beyond a reasonable doubt that this woman, Natalie Cochran, feloniously, willfully, maliciously, deliberately, and with premeditation killed her husband, Michael Cochran. This entire tragedy can be summarized into 3 different blocks of time. September 29th of 2017 through August 26th of 2018, September 1st of 2018 through January 30th of 2019, and January 30th of 2019 through February 6th of 2019, the week that Michael falls ill for the last time.
There may be
now, Michael Cochran was 38 years old at the time that he died. He was a father, a husband, and a son. He was a very fit and healthy man. He cared a lot about what he looked like and a lot about what people thought of him. He lived and worked here in Raleigh County. As you've heard, he worked in technology. He also worked with Workforce West Virginia. Ultimately, he was a minority partner in the Business Tactical Solutions Group, in which his wife, Natalie Cochran, was the 51% majority owner. And we'll just briefly talk about TSG. We don't have to get too far into it, but I feel like we need to cover that ground again. TSG is represented through its website to be a leading supplier to the Department of Defense, national security agencies, federal civilian agencies, prime contractors, and nonprofits worldwide. And we've heard a lot about how the business ended up not being super legitimate. In fact, it wasn't at all. But it originally was set up that way. They had filed with the Secretary of State, it had a business license, and it actually was registered with the federal government to bid on government contracts and to be awarded those contracts. It was held out to be a woman-owned small business, which gave it priority in getting contracts. But a business like this required one thing: startup capital. There was 2 ways that the business obtained startup capital, and that's the money that's needed to get it off the ground and get things running in general. The first way was through investors. And what would happen was Natalie would go to her friends, her family, people in the community, ask them to invest in this company. They were promised a return on their investments when contracts were ultimately fulfilled. They'd get more money back than what they put in. And sometimes, when the money would come back, she would ask them to invest again so they could get an even higher return on their original investment. So some of these people were putting money into this company over and over and over again and seeing very little payout, if any. The other way that TSG gained startup capital was through loans. She would apply for small business quick capital loans. And what that means is these were rescue loans. These were for companies that were in trouble. They would have a very high interest rate and you would have to pay back on them daily. Whoa. And now I'm not saying that Michael didn't know about investors and didn't know about loans. He knew people were investing. He knew there were loans. But they weren't what he thought they were. Some of the loans, he was told, were SBA grants. What's so special about a grant is that you don't have to pay the money back. That money is given to you for a specific purpose. Otherwise, he thought they were getting government bonds. Specifically, Natalie held out the loan companies to be factoring companies. And what factoring companies do is they buy all of these accounts receivable that you have, and they'll pay you for a portion of them, and then they'll collect the money later. So that's what she told him was going on. So what happens next is about August 26th of 2018, Michael really discovers the extent of family investors and investments. You heard that he got into Natalie's phone at one point and read her messages, and that's how he found out. He was completely unaware of the lucrative returns and profits that were being promised to people. He was quoted as saying she was giving away our money. On August 27th of 2018, Natalie sent a message to a few family members, which we've put in evidence and you all have seen. Hey guys, after the contracts that are out pay off, I will have to stop subcontracting. I wasn't as transparent with Michael as I should have been. After this, Michael and Natalie made rounds to family members trying to pay some checks, try to pay some people back. But ultimately, Michael realizes that the amount of money that they owed people is a lot more than he knew. So now he wants to be more involved and understand how everything works. On August 27th of 2018, Natalie sends Michael this message, this series of messages. 3.45 million should post tonight at midnight. 300,000 should post Wednesday. 1.25 million on Thursday. 724,000 Monday of next week, and 2.56 million next Friday. You've heard that Michael was spending money. This is why. This is why he was so charitable. You heard that he donated a weight room to a middle school. He bought uniforms for youth sports. He bought a house for a youth pastor who had nowhere else to go, and later rented that house out to Chris Davis's recently widowed aunt. He was trying to give to people. And he'd been led to believe that this legitimate business was thriving and all of this money was due to them. She set a prize date, though, when she did this. All their hard work was going to start paying off at midnight. So what did this ultimately do? It created a big problem. It created a bunch of promises that Natalie couldn't fulfill. And those promises totaled, at this time, $247,499,232.
Whoa.
So in our next time frame, Natalie starts to claim that the government is conducting an audit of TSG. And she uses this as a reason that they can't pay money to investors, a reason they can't get contracts, they can't get paid on outstanding contracts, and the reason that they're not seeing any returns. So she solicits 2 more investors. One of those was Chris Davis. He told you about that. She obtains 3 more rescue loans. On October 25th, Natalie tells Michael the audit is complete. We're going to have our money October 29th. So what happens right around that time? October 31st, Michael goes to the hospital. He's expecting $248 million on October 29th. The money isn't produced. On October 31st, he's sick. He goes to the hospital and he gets discharged, but he's not well, he's not better. And the defense would have you believe that Michael was incredibly sick all the time, that he left the hospital, went back to the hospital because he got sick all over again. No, he was sick one time, he just didn't get better. It happens all the time, all over the world. When Michael went back to the hospital on November 2nd, Natalie reported that he had had a seizure. That was never confirmed. You heard experts testify that the seizure activity in the records was reported by the defendant. Everyone else who testified said they had never seen him have a seizure. At that time, he had his friend Chris Davis take him to the hospital because he wanted to be treated. Nobody wants to feel the way that Michael felt. But other than this, he was healthy. You would think that he was sick, though, because he was stressed out of his mind. Because he was waiting for $248 million that had been promised to him that he hasn't seen. But it still isn't coming. And there's a whole lot happening during this time. A phrase that we've been throwing around a lot on our team is that Natalie Cochran involved everyone and included no one. So on December 4th, BB&T is closing the Cochran's accounts. Michael goes to BB&T, and you've heard about that. He is irate. In fact, his friend Chris Davis is called to come down to the bank because Michael is causing such a scene that there is fear the police are going to be called. He's angry because he thinks these accounts closing is why he's not seeing any money. So ask yourselves, if Michael was involved in a felony-level financial crime involving hundreds of thousands, at this point hundreds of millions of dollars, why would he go cause a scene at a bank and potentially get the police called on him? He didn't know what was going on. And this is where Natalie gets lucky for the first time. On December 6th, the government's already partially shut down and is only funding certain departments. Now, I'm sure we all remember the government shutdown because it was a really big deal and a lot of people had a really hard time because of it.
This is true.
On December 22nd, the entire federal government shuts down. So we've gone from an audit to a federal government shutdown, buying her more and more time. And the shutdown becomes the reason that they're not getting paid. Now, Natalie has told Michael and all the investors that the money's frozen because of an audit. Now, the government's shut down. Next, she tells people she has cancer, chronic lymphocytic leukemia, which we talked about that a little. We've never found anything that indicates that that was real either. She now has to deliver. So she tells Michael and she tells the investors, on February 1st, the federal funds will be released because the shutdown has ended. So why does the money come in on February 1st? It's January 30th of 2019, and we have entered the week of Michael's illness and ultimate death. So here is where she gets sloppy. Her motive to kill him becomes very clear because he is very quickly catching on. It becomes very obvious who's been running the company, that Michael has no idea about the Ponzi scheme, and more importantly, we're seeing that Michael's about to discover the truth of everything that's been going on. So she has two choices. She can come clean, or she can go into self-preservation, which requires that she take him out of the equation and make sure he never finds out what was happening. January 31st of 2019. Natalie says, I'm on the phone with Bank of America. Michael says, are we 1,000%? Yes, she's sending them with tracking. Money is supposed to hit tomorrow. February 1st of 2019, the fund release date told to investors and told to Michael, no funds hit any accounts. This was a Friday, so Michael knows at this point Monday is the next day he can do anything. So, on Monday, money isn't in there. More excuses. Michael is getting increasingly concerned. Later that same day, she says that she spoke with the wire department. All of this money is about to come through. 4.8 million in the morning, 23.8 tomorrow sometime. Michael says, shit, can't do anything today. Michael was just like the rest of us, as you can see. Doesn't make any sense.
Only we can't.
I certainly don't think it makes any sense, ladies and gentlemen. And that's because nothing he was told was true. So let's get into Michael's murder. February 4th of 2019, Natalie sends Michael a text message. I'm at the pharmacy. Need anything? Now, if you'll recall from Dr. Halsey's testimony yesterday, on February 4th of 2019, Natalie was picking up her prescription for Xanax. which Dr. Halsey also testified is a benzodiazepine. Michael is allergic to benzodiazepines, as you've all heard. On February 5th of 2019, Natalie goes to Access Health and sees Dr. Halsey with flu-like symptoms. She says she's vomiting, she reports a fever. She's negative for the flu and strep. She got a steroid shot and labs that day. Now you'll note that this is the doctor who, she said, put her on such a high dose of steroids. That was her words, high dose of steroids. As we'll later see her tell Jennifer Davis. But he didn't give her a prescription for insulin. And you heard his testimony yesterday that he didn't instruct her to get insulin. On this day, she also requested methylprednisolone from Stephanie Hamilton. Now, we all know that is Solumedrol. And if you'll recall,
we don't all know that.
Vial of methylprednisolone was later recovered from the Cochran residence when the search warrant was executed. FBI analysis told us that that bottle had never been used. The same day, Natalie reaches out to Albatross Air, the Kearns family, and schedules a flight for her and Mike to take the following day to Lynchburg, Virginia. We've heard a lot of talk about that flight. You heard from Court Nexon, who is a former Bank of America employee. And he told you that the Cochran's account was never funded. There was never money in their Bank of America account. Mike couldn't understand why. So sure, they were going on this trip to fill out signature cards and things like that. But they were also going to find out why contract funds weren't posting to this account. Why all of these wire transfers we've heard of were not coming through. And if they went on that trip, it would have changed everything. So on February 6th of 2019, the last day that anyone sees Michael Cochran conscious, 6:34 a.m., Natalie Cochran texts Chris Davis. She tells him she can't go to Lynchburg because she has a fever of 103 degrees. Now you'll recall she asked Stephanie Hamilton to bring a thermometer over because she apparently didn't have one. 6:35 a.m., Natalie texts Josh Kearns at Albatross Air, cancels the flight to Lynchburg because she has the flu. Mike tells Natalie to tell Court Nexon and his boss that they won't be there today because she's sick and they'll come tomorrow. But if they still need him to come today, Mike will go and he'll take his friend Chris Davis with him. They'll come back and get her signature card notarized. Mike very much wanted to take this trip. 6:37 a.m., Mike tells Natalie to get Court Nexon to wire them $5,000 to $10,000 from their account. The account that is still sitting empty at Bank of America. Natalie tells Mike she's already canceled the flight and he tells her to reschedule it for the next day. And this, ladies and gentlemen, is the text canceling the flight to Lynchburg, wherein Natalie says that she's been up all night with the flu, which we all know she was never diagnosed with. Later on February 6th, she sends this text message to Michael. I'm in the doctor's office getting swabbed again, getting a Prometh shot, getting you and I both meds. Now Mike is currently out and about in town. He goes and gets some Starbucks at 8:37 in the morning. Natalie arrives at Access Health at 8:10. And she says she's getting them both meds. Now, you heard Dr. Halsey testify yesterday. He didn't see Michael that day, and he did not prescribe anything for Michael that day. In fact, the only medications that Natalie was prescribed that day were promethazine tablets. Promethazine, which Michael is critically allergic to. So what did she tell him that she got him? And isn't it interesting that Natalie Cochran runs straight to the doctor at the first sign of trouble? Frequently. But let Michael Cochran lay on the couch for 6 hours, unconscious. And let's ask ourselves how Michael was feeling around this time. Well, you remember Jason Bowen telling you he quote, felt like he was being poisoned. She later texts Jennifer Davis, "We are both sick. So they put me on such high-dose steroids I have to start taking small insulin shots. Gonna have to order a vial." Again, there's no records that support any of this. There's nothing that indicates that she needed insulin for any reason at all. And if Mike was really keeping insulin in the house for his bodybuilding that everyone keeps talking about, why couldn't she use that? Why would she need to get it somewhere else? And I'll also add, the last text between Michael and Natalie Cochran is at 8:51 a.m. on February 6th. Following that was a 15-second call at 8:52 a.m. And this is the last time we know of that they spoke with each other. Later on, as we all know, Jennifer Davis offers up a vial of insulin because she's a good friend. She's worried about Natalie. She thinks her friend has cancer. She thinks that she's dying. She's doing everything she can to help. So she offers up her own son's vial of insulin. Natalie sends another text to Jennifer Davis. "Mike's sick today too. He didn't get anything prescribed for him. He didn't go to the doctor. All that we've heard is that he laid on the couch for a couple hours." Chris Davis shows up a little while later, and as we all know, drops off a bag, which he testified that he never looked in. His wife, Jennifer, told us exactly what was in the bag. Some Propel, a Diet Coke that Natalie asked for, and a brand new, unopened vial of Humalog insulin. Jennifer says, "You're welcome, but that's nothing. I sure wish I could do more for you." And Natalie's words are, "That was perfect." And I bet it was. Another message she sends Jennifer Davis, "Mike was so mad this AM about not being able to go today. He had to take 2 of my blood pressure pills." Now, the last documented communications from Mike's phone, 11:15 a.m., John Hamilton told you he called and didn't get Mike. He leaves a voicemail message. 1:39 p.m., which you heard testimony today, we believe Michael was unconscious at that time. A text goes from Michael's phone to Matt McCormick. "Should be good, buddy. I'm available all weekend too. Whatever works best." "12:29 on February 6th of 2019, Natalie Cochran takes this photo of her husband Michael laying in their kitchen floor. Now, ladies and gentlemen, I don't know about you, but if my husband had a serious medical event and was lying unconscious in my kitchen floor, I wouldn't be taking pictures of him. I'd be getting help."
He's just
The
unconscious.
first person she sends it to is her sister Penny, who testified that her reaction was, "Well, what does she want me to do about it?"
That picture got me demonetized.
And I think
last
we all
time
know the
showed
answer to that
it.
question. Next, she reaches out to John Hamilton, who you heard testify a few days ago. She tells him, "Mike is sick like last time. Last time when he asked to be taken to the hospital. Last time when he wasn't left unconscious in his kitchen floor." John heads that way, and Natalie then calls her private contractors, Jason Bowen and Jonathan Miller, to come to the residence and help. You heard Jason testify that they were at Lowe's at the time. The story he was given was that Michael threw up in the sink and then used the kitchen cabinets to lower himself to the floor. Jason and Jonathan arrive, and they move Michael to the couch, and Natalie begins reading them vital signs that they can't see. That includes his blood sugar. Why would you check the blood sugar of someone who doesn't have diabetes or any known problems with regulating his blood sugar?
Ladies and gentlemen, I'll posit to you that if he were just sleeping it off like she wanted him to do, he would have felt that finger stick. I've had 100 finger sticks. I know what they feel like. You're not going to sleep through that. At that point, she reports that his blood glucose is 145, and this is at 1:06 p.m. John Hamilton shows up shortly after that, maybe 20 minutes after she contacted him the first time. He told you that Michael was already laying on the couch when he got there. He immediately asks, "How are we going to get Michael to the hospital?" Natalie's response is to let him sleep it off. She now tells him that Michael was sick and had a seizure. John noted that he had never seen Michael have a seizure.
Thank you.
John then contacts
Michelle.
his wife, Stephanie, who is a physician assistant, as you all heard. He asks her to come over and, quote, get her to take him to the hospital. So Stephanie arrives a little later and takes Michael's temperature. She made it a point not to startle him and even warned him that she was going to be taking his temperature. But he doesn't wake up. Stephanie also tells Natalie that Michael needs to be evaluated. Natalie again declines and says Michael wouldn't want to wake up in a hospital. Stephanie even gave her an out. She said, he can blame me. Also, at some point during the day, Natalie and Mike's kids come home from school. And Natalie's sister, Penny Lowry, arrives.
Thank you, Carol. Really gives
Penny
you
told you that Michael had an accident. And she held a blanket up while Natalie changed him into dry clothing that was retrieved by Natalie and Michael's daughter, Nicole.
Thank you.
Thomas Treadway shows up later.
Love the sticker.
When asked if he believed Michael needed to go to the hospital, he told you he's not a medical professional. Natalie's text messages indicate otherwise. They indicate that he believed Michael was getting worse and that he needed to be checked out. So you decide. At 4:34 p.m., Natalie reports that Michael's blood glucose is 115. She tells others that Stephanie Hamilton took that reading, but Stephanie Hamilton took the stand and told you that was not true. Lastly, Chris Davis, Michael's best friend by all accounts, arrives at the residence. He told you how he ran his thumb up the sole of Michael's foot to see if he could startle him awake. He told you that he tried a sternal rub. Nothing. His words to you were, he is going to the hospital, and I'm going to take him. At that point, he and Thomas Treadway load Michael into the back of the Cochran's car, where Natalie rides with him as Chris drives him from 4H Lake Road to Raleigh General Hospital.
Thank you, Kim. This is a good
When Michael
closing.
arrives at Raleigh General Hospital, his blood glucose was 21. That's a far cry from 145 and 115. Seemingly, it's plummeted out of nowhere. You heard from Dr. Uribe and Dr. Krieger. The only reasonable explanation is exogenous insulin administration. And ladies and gentlemen, the defense has posited to you that if Natalie Cochran injected Michael with insulin, whoops, dropped the needle. Here's the good news, I brought it back up.
She just broke a needle. She's waving
He would
needles
have
around.
felt it.
Where's she getting the needles?
Now,
All the
this
camera
is
are like, we want this close up.
You know, I'm going to object to this demonstration. This is bringing outside the evidence before the jury.
this is a demonstrative exhibit, Your Honor.
Overall, it is a demonstrative exhibit used in closing arguments. Members of the jury, you are the judges of the evidence. This is a demonstrative exhibit. I want you to rely upon your recollections and your memories of what the evidence has been in making your decision. There's a certain rough and tumble that we allow and some latitude in terms of closing remarks. I'm going to, as I say, overrule the objection and permit counsel to proceed.
Lois, thank you.
Ladies and gentlemen, I want you to
thank
see
you
the
as well.
size of an insulin needle.
It's tiny. Just gonna leave the sharps laying around?
That needle I just showed you holds 30 units of the kind of insulin that Gavin Davis was prescribed and that was received by Natalie Cochran from Jennifer Davis. Dr. Krieger told you how small a unit of insulin is, and you can see it for yourself. Extremely small. I would also say we made it pretty clear yesterday that the defense experts did not have the full picture. They had incorrect and incomplete information, so how could they make an informed opinion? And when Michael arrived at Raleigh General, as I said, his blood glucose was 21. He was immediately intubated, and he never woke up. February 7th through 11th of 2019, Michael was transferred to Charleston Area Medical Center, CAMC. His MRI there, as you've heard, showed diffuse hypoglycemic encephalopathy.
Thank you, Cheryl. Appreciate
Brain
it.
swelling caused by low blood sugar. February 10th of 2019, Michael is transferred to hospice care at his wife's request. He spends 5 hours there before he dies. Now you'll recall during Thomas Treadway's testimony that he advised Natalie needed to remember that she took his vitals that day and that she needed to make a timeline of the events leading up to Michael's death. Why? Here's some of the different stories she told. Michael was sick in the sink and fell. Michael was sick in the sink and lowered himself to the floor. I heard him hit his head, and when I went in there, he had fallen.
That's the worst one.
She also said he was vomiting in the sink, had a seizure, and then hit his head. And that's just a few of the stories we heard.
How do you know he hit his head if you didn't see it?
Now, a search warrant of the Cochran residence was executed on June 25th of 2019. And I would note that TSG has continued business up to this point, even getting additional investors after Michael's death, including the Hamiltons.
Late but present, thank you very much.
During this time frame, Natalie also pled guilty to the charges that you heard about in federal court, the wire fraud and unlawful monetary transactions. During the execution of that search warrant, a lot of things were found and taken from the Cochran residence. Of note for us was the unopened methylprednisolone vial and the insulin that she kept in her refrigerator. Now, if you remember when Lieutenant Bledsoe testified, he told you that when he reviewed the property receipt from the search warrant with Natalie Cochran, she flipped through it and immediately went to the insulin. And she said, "I keep that for my neighbor's son who has diabetes." Ladies and gentlemen, as I stated previously, the elements of first-degree murder are a felonious, willful, malicious, deliberate, and premeditated killing. Felonious is simple. Murder is a felony, and it's against the laws of the state of West Virginia. Willful or deliberate would mean that someone took an overt action in furtherance of an anticipated result. She injected Michael with insulin. Dr. Krieger and Dr. Uribe testified that there was no alternative reasonable explanation for Michael's blood sugar to be 21 other than outside insulin administration. She also let him lay on the couch for 6 hours. She brought in all this help over and over just to refuse it. Malicious, showing or having a desire to cause harm. Natalie was a diabetic counselor and a pharmacist. She knew that injecting insulin into a non-diabetic would cause harm. She chose over and over, after repeated pleas from friends and loved ones, to leave Michael on the couch, laying in his own urine. She also showed a complete indifference for human life when she continued to work on contracts and make plans for bingo while her husband lay dying in the hospital.
Bingo.
Premeditation.
She says not true.
She obtained the murder weapon in advance from Jennifer Davis. And poor Jennifer had no idea what she was getting herself into when she did that. She had a clear motive, and you saw that leading up to this date, Michael was about to find out what she was doing to people. Do we know what he was going to do with that information? We never will, because he won't have the chance to tell us. Michael was killed because following the actions of the defendant, he was admitted to multiple hospitals and ultimately passed away at hospice. Well, there's a couple of defense theories that I just want to go ahead and debunk while we're here. The first being, Natalie was a pharmacist and could have gotten undetectable drugs to kill Michael. Those were defense counsel's words. She did, just not as a pharmacist. She hadn't worked in pharmacy for 2 years at that point. Insulin can be bought over the counter. Stephanie Hamilton debunked this one. She testified that Humalog, the kind of insulin that was used to kill Michael, cannot be bought over the counter and has to be obtained via a prescription, which neither Natalie nor Michael had. Michael was a, quote, ticking time bomb. Michael's previous illnesses can only be verified by Natalie. No one else ever saw him have a seizure. Sure, he went to the hospital, but they were never actually able to verify that seizure activity occurred, only that it was reported at home. By her own words, Mike was doing the best he had ever done in his life. You heard testimony that he forgot where he parked his car. Ladies and gentlemen, I don't know about you, but I forget where I park my car all the time. It's very common. He participated in tough man competitions and Jeep pulling competitions. That doesn't sound like a sick man to me. You also heard that Michael was on steroids. Chris Davis testified that Natalie told him that she was in charge of all of his supplements and vitamins. No steroids were recovered from the Cochran residence when the search warrant was executed. The Mexican supplement that we've heard about turned out to be a female fertility drug that came from Florida. You know who had communication with that company? Natalie Cochran.
Oh, she's not liking this.
Ladies and gentlemen, in closing, Natalie Cochran had the means, knowledge, and opportunity to commit this crime. She dosed Michael Cochran with insulin that he was not prescribed and that he did not need. You may not have done the math, but I have. Next Thursday will make 6 years to the day since she injected Michael Cochran with insulin in his home. 5 days after that will be 6 years since Michael Cochran left this earth. 6 years since 2 children lost their father. 6 years since this woman, Donna Bolt, and this man, Ed Bolt, lost their son. 6 years since they were able to see him for the last time. Michael and the people that loved him deserve to have the most thorough investigation that we could conduct. And we've done that. We've done everything we could to show you what really happened to Michael. These people have waited long enough for justice. Michael has waited long enough for justice. Ladies and gentlemen, I'm asking you at this time to deliver that justice and to find his wife, Natalie Cochran, guilty of the first-degree murder of Michael Cochran. Thank you.
Mr. Victor.
Mr. Victor has to deliver here.
State, ladies and gentlemen of the jury.
Can I have your needle? She says, "This is my needle." This is my needle.
About 2 weeks ago, when I stood in front of you, I told you a couple of things about this case. And one was that Natalie Cochran was guilty of financial fraud, of financial shenanigans, and that she was indeed guilty without any reservation. But we're not here today to retry that case. And everything that the state is telling you about Natalie Cochran, yes, let's shed some light.
That was me, sorry.
Thank you, Judge. Everything that we've heard about this financial case from Natalie's standpoint is true. She was convicted. She was a participant in the Ponzi scheme. But we're not here to judge her yet again on the financial crimes. We are here to judge her on the murder of her husband. And the state cannot prove first-degree murder against her beyond a reasonable doubt. The state cannot prove three things. The case cannot prove what, the case cannot prove how, and the state cannot prove why. First question, what was Michael Cochran killed by, or what killed him? And you've heard the evidence over the last 2 weeks that we don't know. The experts that the state brought testified to what they themselves admitted, a definite maybe. Maybe it was the insulin shot, and maybe not. The experts that the state brought testified to, we cannot determine the objective factors, the objective anatomical findings, and tangible demonstrative evidence what killed him. They don't know. The state's expert, Dr. Krieger, said, well, the hypoglycemia due to the insulin administration is a strong possibility, but it's just a possibility. Why don't we know what killed Michael Cochran? Well, because they did not perform the autopsy. And by the time all these experts got the evidence, Michael Cochran's body was so decomposed that it is impossible medically to determine what killed him. And you heard the testimony of two defense experts. And you also heard the testimony of my compatriot, Dr. Piotr Kubicek, who is the medical examiner who performs autopsies on a daily basis and who is, I would submit to you, a little bit like Matlock. He is the medical detective trying to detect what is the crime that led to the death of that particular individual. All these experts said the same thing. The cause of Michael's death is undetermined. We don't know. The state cannot answer or prove beyond a reasonable doubt the how. How did that happen? How did this murder happen? I'm not particularly good with syringes, but
someone's getting poked.
Well, we'll come to that. The state wants you to believe that there was an insulin shot injected into Michael that killed him. But then the state also tells you that it could have been more than one insulin shot. Because when Michael arrived at the hospital, his sugar level was 21. And the experts told you that it's impossible to have that type of sugar level without being pretty much continuously shot with insulin. So, how did that happen? Well, let's follow the state's theory. This cold-blooded killer is planning a murder of her husband with the insulin shot. In that regard, she is calling her friend, Miss Davis, asking for insulin on the day of the injection of that insulin. I might just as well have asked for a gun. Might just as well have asked for a murder weapon. Jennifer, I'm trying to kill my husband later today. I need the insulin, and I'm trying to kill him with insulin. I need you to bring me some insulin. Is that the action of a planning cold-blooded killer? She would get that insulin ahead of time, not on the day of the murder, and involve two witnesses against her right there and then, who came here to court as predicted and testified that that was, and they gave her the insulin. And then, how on earth did she inject that insulin into Michael? Well, let's look at these facts. Did she approach Michael from the front when he was facing her in the kitchen? And if she had the insulin injection in her hand, wouldn't he have the time to react and say, what is going on? Let's assume for a moment. Then she approaches him from the back when he's standing in the kitchen, and she jabs him either in his back or his rear end. Well, she has to have a couple of seconds to inject this insulin in him. Basic human reaction would be to turn around and face the assailant, be it his wife or be it some cold-blooded killer, a stranger. She wouldn't even have time to plunge in insulin into his body without him turning around. And he's an athlete. He's this huge guy. And here's his 5'1" or 5'2" wife who's injecting him with insulin, and he doesn't react. That's why I said it didn't happen in silence. My first reaction would be, what on earth are you doing, woman? Or whatever he calls her. What are you doing? And then, somehow, he drops there in a fetal position in the kitchen? No, that didn't happen that way. Of course it didn't. So now, you heard the evidence from at least 4 or 5 witnesses that this type of insulin acts in a delayed way. 10 minutes, 15 minutes, up to half an hour. If I'm jabbed, even by my dearest wife, or by somebody else with a substance, and if she is silent, that's one thing, and if she tells me, this is for you, you son of a gun, I hate your guts, whatnot, here it is, I'm killing you, I would have 10 to 15 minutes, maybe to 20 minutes, to 30 minutes, to call 911, to run to the hospital. I told you it was 7 miles from the hospital. He would have been in the, I know it's February, but he would have been in that hospital sooner than you can say hello, sooner than you can slap a tick. He would have been in that hospital asking for help, an immediate sugar reaction or sugar injection to bring that insulin level to some normalcy. He wouldn't have taken it in silence. He wouldn't have just dropped down on the floor. So how did it happen? Well, the state then gives you an alternative, because now they're changing their theory. That may have happened in bed. Ah, that's a novel idea. Inject him in bed, he would not have reacted? Of course he would have reacted. He would have gotten up and he would have done the same thing. He would have taken himself to the hospital, he would have called 911. He would have probably not been particularly happy with Natalie, but that doesn't mean anything. He could have saved himself. So then the state changes the theory again. That may have happened upstairs, or it may have happened on the couch, or he's injected on the couch. Well then, okay, so he doesn't get up, so who takes him into the kitchen and puts him in this fetal position? That didn't happen, ladies and gentlemen of the jury. And how do we know that? He fell in the kitchen because there was one witness, and he hit his head against the counter because there was one witness, and that was the sister of my client, who told you that she saw a dent, a fresh dent in the counter, in the kitchen counter. That's where he hit his head, and that's how he fell on the ground, on the kitchen floor. But not because of some insulin injection, but because of some unknown condition that was caused, or may have been caused, by many, many, many different reasons. Now, then, continuing with the cold-blooded killer's action, she does not do anything but call all kinds of people to the house. Now, wait a minute. You have just decided to kill your husband. He is unconscious, let's assume, and you want him dead. Well, let him die then. Don't do anything. Or maybe put a pillow over his head and kill him. But do not tell me that you want to kill your husband and then you call 2 workers right there to bring Michael onto the couch. The sister and her husband, the state trooper and his wife, who is a medical assistant, and then Mr. Davis. Is that the action of a killer who wants to get away with murder? No. 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 And then, and again, I told you, that's the kicker. Then he dies, and she wants to hide all the evidence. She cremates him. And then all the evidence is gone. All these Dr. Kubitscheks and everybody else can look at all that evidence. No, they can't, because he's cremated. That's how you, I guess, kill somebody the way the state believed it happened. But it didn't happen that way. And then the ultimate question, and the question is why? Throughout this case, the leitmotif, the state's main motif in this case was Michael didn't know anything about this business. Didn't know anything about Natalie's shenanigans, financial, the fraud, the deception, the lies. He didn't know anything about it. Well, I think that from the very first day, ladies and gentlemen of the jury, you've realized that this is not the case. But let's assume for a moment that Michael is indeed blind and doesn't know anything about millions of dollars, hundreds and thousands of dollars. He doesn't realize where all that sudden wealth came from. Doesn't know anything. And then he finally finds out. Let's assume that he finds out. And then the state tells you that he would do what Well, the state cannot tell you. And the question is, what would he do? What would he do that would be so bad that would require Natalie Cochran to kill him? I mean, scenarios abound. You find out that your spouse is cheating the government, cheating the investors. What do you want to do? Well, you probably want to say, come on, let's get a lawyer. Let's get an accountant. Let's try to work it out. Let's call these investors. Let's try to pay the money back. Let's file for a bankruptcy. Let's maybe even talk to a friendly prosecutor in Raleigh County. Maybe you will have to do a little bit of time. But not run to the federal government and complain. What, was he going to kill her? Is there any evidence that she launched this preemptive strike against him because he was going to kill her? Or that he was going to do something to her? Divorce her? What? What would be her motive to kill him? Why? She may have been afraid that he would be mad, but to kill him? To eliminate him? From what?
Call.
From doing what? From going to the federal government? From complaining that my image is so tarnished now in the community that I want to divorce you and you will be penniless and all of that? There's no evidence of that, ladies and gentlemen of the jury. What triggered this murder? The state cannot answer that question. But if you had any doubts about Michael being involved in this scheme, and if you believe that he was, then the state's entire case collapses. Because she, Natalie Cochran, would have no reason to kill him. Because he, Michael Cochran, was as involved in this conspiracy as she was. And how do we know it? Well, he was working on these contracts daily, on these federal contracts daily. Even when he was hunting with his little son, he had a contract that he was working on. He was working on the contracts when they were in bed. And I'm not talking about anything sexual here. I'm talking about family. She's watching the TV. He is working on the contracts. Their little son with them, sitting between them, realizing that dad is working on the federal contracts. He signs the checks from the company.
I'm going to not.
He has access to everything, every bit of information that goes through this company, checks, contracts. He has access to all of that. And besides, is he really living on a different planet from Natalie? Ladies and gentlemen of the jury, if I suspected my wife, we are, well, unless I'm in court, we're home. We're together. We spend time together. We communicate. Wouldn't I ask my wife, honey, where is all this money coming from? All of a sudden, I'm not working. I'm this computer tech guy. You're not working. All of a sudden, we're buying 2 boats. Well, the investors, yeah, but now we have 3 houses. Now, we just got back from Paris. Ladies and gentlemen of the jury, you've heard the evidence of incredible wealth, incredible injection, maybe that's a bad word, injection of wealth that Mr. and Mrs. Cochran had in 2018, 2019, maybe even 2017. And that came from the investors. And the investors dealt with Michael individually, just like his parents. They gave him some $44,000. He knew that there were no contracts. What contracts were they? What contracts were there? He didn't have a clue about some of the business, I'm sure. but he had deep, profound knowledge of how much people invested, who was gonna get paid for what, federal contracts. He had deep, profound knowledge of it. I'm sure there were some aspects of this business that he may not even know about. And I'm sure that Natalie was involved in this. But she is not here on trial for fraud. She's here on trial for murder. Well, let's look at the state's case. And mind you, the state has a very heavy burden, and the burden of proof, beyond a reasonable doubt. Well, the state brought the evidence of the pilot who says, well, the flight was canceled. Okay. The banker turned mind reader. He had an idea why the flight was canceled. But of course he didn't. He is mad at Natalie because he had to do all that research for the company and didn't get paid for it, I'm sure. And for him, time is money. So they didn't fly to Lynchburg. Well, Natalie went to a doctor. She was sick. I think that the state attributes all these nefarious things to her, but isn't it just plain obvious from Dr. Halsey's testimony that she was sick? She was sick on Friday and she was sick on Saturday. And what did he give her? He gave her a steroid shot that increases blood sugar. So she's calling her friend, Miss Davis, to get her some insulin to maybe level off the sugar, blood sugar. What's so unusual about it? No, it's nothing unusual about it because she, Natalie Cochran, had a long-standing relationship with the Davises, who had a misfortune, a tragic misfortune of having a child who was diabetic. And Mrs. Davis came here and told you, no, Natalie never had any insulin. Oh, really? But then when we confronted her with the pharmacy records, she said, oh yeah, Natalie could pick up the insulin. But she was bringing it home. Well, what if you weren't home? Yeah, she doesn't explain it. Natalie could keep it at home. That was nothing unusual about Natalie having insulin. And you know what? The state wants you to believe that this insulin, that bottle of insulin that was found, was the weapon, the murder weapon. That somehow it was punctured and she kept that bottle as some kind of sick souvenir of the murder? Is that what the state telling you? I submit to you, ladies and gentlemen of the jury, if you look all you need to look at is this humologue that we introduced in the exhibit, as an exhibit. I'll submit to you that a blind fool would tell you that this bottle is full. This bottle is full. There is nothing in this bottle that has been taken. There's no bubble, no nothing. The bottle is full. I suspect I know what happened, why there's a puncture. All these FBI gentlemen got that bottle and maybe had taken a little sample of what to determine what it is. That may be the puncture. But otherwise, the bottle is full. We're not going to sit here and speculate. They find a bottle, a vial of insulin that is full 4 months after the demise of Michael Cochran. And then, that's part of their evidence. Remember Mr. Bledsoe telling you at the end when we finally pressed him, is there any evidence? Is there any evidence that the bottle that you have was the murder weapon? And the answer was no. And ladies and gentlemen of the jury, the lifelong condemnation of this woman versus complete exoneration is at stake. The stigma of conviction for murder versus letting her go free is teetering in the balance, and the state has the audacity to come here with an item that is not the evidence, and they're trying to tell you to convict this woman of murder based on something that is not the evidence. Is that the case that the state has the audacity to bring before you?
Barb Russell, welcome to the gallery.
Let's look further. Chris Davis and at least one other witness, Mr. Treadway, and Penny Lowry, knew that Michael Cochran was taking all those steroids. Whatever, steroids maybe. Maybe they were steroids. Maybe they were not steroids. Maybe they were anabolics. We don't know. Michael was taking substances by the fistfuls. And they can say that, oh, we have isolated one little vial and that was some hormonal thing from Mexico. No, ladies and gentlemen of the jury. He had a cabinet full of medications. He had a cabinet full of that away from the family, away from the cabinet for or a place where the family stored the medication. He was getting this stuff online. He had the United States Postal Service box where he would get all that stuff. And I submit to you that this was not some one deal Mexico thing. And there's nothing wrong about Mexico. This was, however, the problem. He was getting substances that were not approved by the American government, by the the Food and Drug Administration. He was getting substances that were going to increase his physique, his appearance, but my God, they could have done some serious damage and probably did some serious damage. One of them was not even for human consumption, as the children told you. That was just a sample of what Michael Cochran was taking. And what he was not taking was the medication that was prescribed to him by the physicians.
Helena, thank you very much.
And yes, he had all kinds of conditions for which he had the medications. He had Keppra, he had all kinds of serious medications which he didn't take. Because he believed that all the doctors were quacks. He believed that they were not the people to be trusted. Chris Davis and Mr. Treadway and Penny Lowry tell him, you have to stop this stuff. You really cannot do this. And what does he tell Penny Lowry? She testifies. He said, "Oh, retarded Penny. What do you know? I'm gonna do whatever I want to." The state makes a big deal out of Michael not being taken to the hospital. But you have witness after witness who told you that Michael not only believed that the doctors were quacks, but he hated going to the hospital. He vowed to kill somebody if he's ever awakened in a hospital. And why? Because he considered this a waste of time. Now, he had all kinds of problems that he went to the hospital with, and within the last 3 months of his life, he went to the hospital 3 times. October 31st, and then he stayed there for a day. I told him he had all kinds of problems. Then he went back to the hospital with pretty much the same conditions that he had now. and stayed there for 5 days, and then he came out. You heard throughout this trial that Michael had convulsions, seizure-like activity. He probably had epilepsy. The doctors told you that. He had a brain mass that was later modified into the brain swelling, encephalopathy. Ladies and gentlemen of the jury, those are serious conditions. They are not to be laughed at. Those are very serious conditions. He retained urine. He had an enlarged heart. He had an acute respiratory failure. He couldn't even breathe because he had a chronic sinusitis. Nobody is here to desecrate or dishonor his life. He died much too prematurely. He died at the age of 38 years. Not for a moment should you think that the defense is taking his death lightly. No. It's a horrible tragedy. Horrible tragedy. But a tragedy, not a murder. It's a tragedy, ladies and gentlemen of the jury. But with all these conditions, Michael was still doing what Michael was doing. Taking supplements, anabolics, substances that God only knows where they came from. And who approved them? And he was a ticking bomb. How do we know that?
Who is shredding paper on the microphone in the background?
His second stay in the hospital, at least 3 witnesses told us that Michael's health has deteriorated to the point where Michael was not the same guy. When he was Michael at his best, he was generous, gregarious, going to parties, participating in tough man competitions, lived life to the fullest. He was focused. After his second stay in a hospital, Michael could not find his car in a parking lot. Forget that. That happens to me quite frequently. But that was just one symptom. He could not fix a light fixture.
Just forget that. I do
with Mr. Davis. He felt confused. The children testified he had constant headaches. He was irritable. He didn't know where he was. Mr. Treadway came here and testified Michael hated going to Panera Bread with a passion. He hated the restaurant completely. And I know that this is not a case about Panera Bread. But if I hate a restaurant, I'm not going to set foot there. And yet Michael went there and could not even recognize the fact that Mr. Treadway was wearing the same hat that he's been wearing for years. He was confused. There was something going on in his head that made him go where he would never go, and that made him forget who his friend was, really. Now,
we just lost that sponsorship, apparently.
The state brought before you
that's good.
Those
Wisconsin
2
cheddar
FBI agents
from a different place,
who again could not contribute anything scientific except for that bottle. And the state closed the case with 2 law enforcement officers who are here today.
I'm sorry, that's no fun.
Have you ever seen a more shoddy investigation that took place in this case? They never talked to the children. And I know that the state will say, oh, this was not that important. It was important. The children's testimony was riveting in this case, and I'll come back to that in a second. They did not even check what kind of medication this man was using. And for that matter, they have no clue about Natalie Cochran's medication. And, you know, they try to convict her in part because she lied about her cancer. Oh, that's a low blow. First of all, we have absolutely no evidence that she did not have cancer. We have the evidence that she was going to seek help from the Cleveland Clinic, from Duke, from the doctors, wherever she could. And knowing our medical system in this country, it's not that you're going to walk into the Cleveland Clinic and you get treatment the same day. You have to have insurance. You have to have all kinds of, you have to go through all kinds of hoops to be seen by a specialist. And maybe when she told somebody, yeah, I have cancer, leave me alone, because she maybe didn't want to discuss her health with somebody, maybe in reality she was checking out whether she had cancer and went to all kinds of doctors and clinics to obtain that health. And the state believes, oh, she lied because she told you that she had cancer? The officers ignored the federal investigation completely. And in the federal investigation, in the indictment, in the forfeiture proceedings, in the federal case, it's the Cochrans who were responsible for the Ponzi scheme. But the indictment didn't come until September of 2019, and Michael was dead. I submit to you that the federal government was investigating them both. They can come here and say, well, I saw some cases where the couples were not investigated together. That's baloney. The federal government investigated them both and would have indicted Michael as quickly as they indicted Natalie for the same offenses, because Michael was involved in this Ponzi scheme up to his eyeballs. Now, let's see what evidence the defendant presented. Remember Nurse Hawley, if I pronounce it correctly, Hawley, yes, who said that she was at hospice. And what did she observe? Natalie Cochran was with her husband for the last 5 days and held his hand when he passed away. There's evidence that Natalie Cochran got into a car with Mr. Davis. Well, the state said, oh no, she didn't drive him to the hospital. Well, she didn't drive him, but she was a passenger in that vehicle driven by Mr. Davis. She didn't drive him because she was too distraught over his condition, but she still got into the car and held his hand. Is that the cold-blooded killer? She also testified that Natalie Cochran was a go-to woman, and I think that she may have used that phrase, or maybe I have used that phrase, when it came to the emergency situations involving Mr. and Mrs. Davis's child. So Natalie Cochran would have to have insulin. You don't treat insulin with a water pill, for God's sake. You have to have insulin to treat it. And if she was a go-to woman, she must have had insulin to treat the Davis's child. So there should be no surprise again that she had insulin in her possession. Mr. Treadway didn't want to talk to the police because he believed they were dishonest crooks. And he somehow, by the way, he got scammed financially, so he had absolutely no reason to be friendly to Natalie Cochran and testify on her behalf. Similarly to all these other witnesses, even her sister got scammed to the tune of about 50 grand, and yet she came and testified for her sister. What did Treadway tell you? Well, Michael was confused. Michael wasn't the same guy that he had been before. And then Penny Lowry, the retarded Penny, as Michael called her. She told you,
whoa,
not only about that fresh dent in the kitchen counter, but Michael wanted to pay her back what she owed on the contract. Michael wanted to pay her back. Michael was dealing and wheeling with the money from the investors. He knew about it. She told you, again, the same story, that Michael refused to go to the hospital because he was going to kill somebody if he went back to the hospital and woke up there. And we have all these discussions between 5 or 6 people after Michael collapsed in the kitchen. And then I told you that the children testified in a riveting way. And you're gonna tell us, well, the state probably will tell you they're coached, or they were somehow not truthful. Two tragic figures. 2 children who were young enough to be taken care of by father and mother, and old enough to know what was going on around their house. Nikki testified here unequivocally that her father had headaches, he was confused, had a brain fog, was agitated. In a true, genuine, heartfelt way, she told you that he may not have been as loving towards her as he was towards their son. Michael had a heart-to-heart with her shortly before he died, and her impression was that her father felt it coming. And what was it? It was death, ladies and gentlemen of the jury. Michael felt it coming, and he had this heart-to-heart conversation with her, which she considered heartrending, and which we would consider his farewell to life, because he knew that there was something irreversibly wrong with him. The MAC, their son, testified too. Dad worked on the contracts all the time, even when hunting, even in bed. And he testified about their lifestyle. He testified about the supplements, the injections, the dropper, the stuff from Mexico, as he called it. Stuff that wasn't for human consumption. He remembered it all. He testified about his father's anger, his father's combativeness, his father's confusion. Now, I want to talk to you very briefly about, before I do that, there was also a brief mention of nootropics, a medicine that came from some shady, well, maybe not shady, I shouldn't say that,
but
places that usually would not be available in your local friendly pharmacy. There was the smart drugs that Michael was receiving at his USPS, United States Postal Service, box. These were the cognitive enhancers, memory enhancers, stimulants. Michael was perhaps a man's man.
They each get 1 hour.
And he would not admit to any weakness. He was seeking desperately to look great, to be this, I don't know, alpha male, whatever you call it, to be this great, maybe bodybuilder, maybe an athlete. And yet, in all of this, he didn't follow the advice of those who should have given him the advice and who he should have listened to, and instead did his on his own. Now, I want to return for a second to the experts who testified in this case. let's start with Dr. Kubitschek. All of these experts, by the way, had a number of autopsies that performed. But who was in the best position to tell you about the autopsies? Who was in the best position? Well, of course it was Dr. Kubitschek. He performed the autopsy the earliest. And with all the help of the state resources, and relatively early in the game, when the body was not perhaps yet decomposed to the point that nobody could recognize the organs anymore, he told you that the cause and manner of death was undetermined. Then there was Dr. Howley, who was not necessarily an expert, but he told you a couple of nice things. One is about, of course, about Natalie being sick, but he also said something about tablets, the pills, and the state jumped on it. And now the state submitted another theory that maybe Michael was killed by Natalie with pills. For that matter, the state is bringing another theory now that maybe she killed him with the benzos. You heard about the benzos. Now the state says maybe there were 2 shots of insulin or maybe more. Now the state tells you she killed him in the kitchen. Now she killed him in the bedroom. Now she killed him with the prednisone, maybe. And then
maybe she gave him more in the car ride to the
maybe
hospital.
Maybe any other substance.
Lots of maybes.
And the state will stand up at the end and tell you that whatever I tell you is a bunch of nonsense. But, ladies and gentlemen, you've listened to the evidence. If the state stuck to its theory that there was 1 insulin shot, I could buy it. But now the state quietly is telling you, well, we're not telling you that the evidence suggests that the defendant killed her husband with insulin. There may have been pills, there may have been benzos. They're intimating this because they don't have any direct evidence, to which they immediately admitted, but they don't have any circumstantial evidence that fits either. Now, you had Dr. Dragovich, who told you maybe one very important thing, and that is that the decomposition of the body caused the inability of any doctor, for that matter, to assess objective factors, objective anatomical factors, and the findings of any type of specific, concrete reasons for Michael's death. That is impossible. Dr. Uribe believed that there was an insulin shot, but this was just an assumption. It was kind of a bridge to the unknown, and I think that was his phrase. It was just an opinion. Dr. Krieger said, well, we've excluded maybe all the other options, but it's a definite maybe, as we call it. It's a definite maybe. Maybe there was an insulin shot, but we don't really have all that information upon which we can construe our theory. And then Dr. Banerjee came here, and she said, we don't know. She's our expert. Maybe you expected her to say, oh yeah, that was an insulin shot that was responsible. That was some other reason. She didn't say that. She testified like 4 other experts that we really don't know. But there are other possibilities. There was something wrong with Michael's pancreas. Remember that? He may have had pancreatic tumor. He obviously had an enlarged heart. Arrhythmia. Maybe there was something wrong. Maybe that was the reason. The tests were not done on NAC-peptide insulin, no meaningful diagnosis from the sliders that were obtained, or that weren't obtained, could have OD'd on benzos. We don't know. Benzo overdose, maybe poisoning. Hypoglycemia equals death. Well, all of that, and then of course there are other reasons. The medication, alcohol, unexplained medications, liver disease, sepsis, surgeries, immune system, all of this could be taken into account in Michael's death, but the state stubbornly believes that Michael's death was caused by that one insulin shot, which they, by the way, changed and modified to maybe 2 or 3 on all these versions. It's impossible. Impossible, ladies and gentlemen of the jury. Now, the state also brings a theory of maybe there is this voluntary manslaughter, that just because she didn't take him to the hospital. Well, I submit to you that not taking Michael to the hospital was not done over the period of days. It was a matter of hours. It was a matter of discussing Michael's preferences and will, whether he was going to go to the hospital, whether he wanted to go to the hospital, and what was necessary. We had several people in that house who could have decided. Finally, it was decided that Michael was going to the hospital because he was not waking up. Yes, it took some time.
Who made that decision?
But there was always the hope that he would wake up, and wake up in his own home, surrounded by family and friends, and everything would be fine. After several hours, yes, it became necessary to take him to the hospital. But that's all. Now, ladies and gentlemen of the jury, I told you at the very beginning of this case that this is a complex case. This is a case that involves medical, banking, scientific, maybe pharmaceutical, maybe business evidence and information. There are aspects of federal litigation here. And you've heard it all. But
he wrote this
distilled to its essence, this case really involves the state's attempt to equate the federal prosecution and conviction for dishonesty and fraud with murder. The state says she is a fraud, therefore she is a murderer. She is a cold-blooded murderer because she is a cheat. That's what the state is telling you. But the state cannot prove, certainly not beyond any reasonable doubt, the what caused Michael's death, the how did that happen, and why it happened. And so at the end of this case, I will tell you that the state's attempt to equate the fraud with murder is like trying to squeeze a square peg into a round hole. And if that one peg didn't fit, then the state switched the theory, and let's see if another peg that is still square will fit into that hole. Oh no, it won't. Well, then we'll switch to another theory. Maybe benzos, maybe two shots of insulin.
More square pegs.
And it still doesn't fit. Ladies and gentlemen of the jury, the state will have the last word. In the criminal process, I will sit down and I will not address you again. my esteemed
And there was
colleagues
much
and
rejoicing.
friends will get up and tell you that whatever I told you is nonsense. They will give you the spin on the facts and tell you that's the way it is. But I heard a statement once that, and of course when you go to the jury room, since they spoke last, you will have their words in your mind, in your memory more than mine, than my words. But I heard a statement once that it's not the one who speaks last, or trust not the one who speaks last, but who speaks the truth. We have no reason to come here and hide anything from you, ladies and gentlemen of the jury. Ms. Cochran should not be perhaps invited home for you to have dinner with her on Sunday. I told you that. She is committed crimes of fraud, crimes of mail fraud, crimes of dishonesty, but that doesn't make her a murderer. And
you can believe her now.
If you cannot answer these three questions, what, how, and first of all and foremost, why, then the state fails to prove its case beyond a reasonable doubt, and that's why we're asking you to find her not guilty.
There we go. And with that, the plane is out of gas and has coasted to a nice bumpy landing somewhere short of the runway. I don't think that was
reply, Miss Akron.
No, it's back to me.
Oh. Bifurcate. Divide it up amongst
You're
yourselves.
so close to listening to all the stuff. Be silent on this side, and then you will take over. On behalf of the prosecutors...
Bless you. That's what...
In fact, of the prosecuting attorney's office, the investigators, we thank you for your time, your effort, your attention, your sacrifice. Without you, this system cannot work.
That was funny.
Can I touch your equipment? I should have asked.
As he continues to touch the equipment. I should have asked. Push the remote. Point, arm up in the air.
Sure.
One at the ceiling. Here we go. One hand
I
up.
can make duck shadows on the wall while we get this going.
This guy has so many one-liners. This deputy has one job. Copyright Buckler Instruments.
Okay. Yeah.
Copyright
I'll
expired
talk about something else.
2010. It's old equipment.
I'd like to talk with you about two numbers. And the first one
21.
Is this one. 0. The defense is right. We're going to tell you that what you just heard is a lot of nonsense. And the reason why it's nonsense is the defense has no credible evidence to back up any of their theories as to why the state is wrong. Let's start out with Michael Cochran himself. They have a very schizophrenic approach to Michael Cochran. One theory of the defense is he was this macho, bodybuilding, fit guy, athlete, Jeep pulling, super stud guy.
We're here to pump.
That's one theory.
You up.
Now they have some evidence that he was very concerned about his fitness, very concerned about his appearance. We would agree with that. But did that lead to his death? Zero evidence to support that. On the other side, oh my gosh, the guy was a ticking time bomb. The defense words, a ticking time bomb. He was so sickly. He was essentially a guy with 1 foot in the grave and 1 foot on a banana peel. They don't really have any evidence of that either. He was just a normal 38-year-old healthy male. And a good guy by all accounts. So the hospitalizations that they've relied upon to tell you how sickly this man was, where did most of the information come from that? Medical records. Who provided histories for that? The defendant. The defendant told the doctors all of these things about Michael Cochran. It didn't come from other reliable sources. It came from a very unreliable source, her. So his suspected brain mass, his suspected convulsions, his suspected all of these problems, there was no diagnosis of any of those things. They were suspected. And they were suspected because she told them to suspect that stuff. But there was never a diagnosis. Even their own experts confirmed that. There are other witnesses. The fact that the Davises talked to a nurse to have Natalie Cochran, their emergency contact, that's not the same thing as authorizing treatment by Natalie Cochran of any child. There's zero evidence of that. There is evidence on the other side. The Davises told you they never gave the defendant insulin for the benefit of their child. Never. Both Davises told you that. As recently as yesterday, the defense was still putting that theory out there for you to consider. There's no evidence to support that. Zero. Mr. Treadway's testimony was Mr. Treadway's testimony. This is a guy that didn't want to help the police. Even though his best friend was dead, he wouldn't talk to him. And he had some newspaper article he said gave him justification for that. That's on him. Treadway's got to live with that. But he didn't bring anything of substance to this case, did he? No. The two children that testified, they are tragic figures. They have had a terrible 6 years. They lost their dad. For the time being, they've lost their mom. But they were little kids. And their testimony had a certain ring to it.
Yes,
they both picked up on the same word, agitated. That's an unusual word. Rolling back time 6 years, think that the oldest was 20. She was 14 at the time. And that's how she's going to describe her dad the last few weeks of his life, the word agitated. Her brother, the same word, and he was younger than her. There's something odd about that. The state believes that they sincerely believe their recollection. But does it make sense? Would kids that age really be that involved in their parents' business?
Helping with a 50 cal
Would
contract?
Well,
at 10?
it's possible, but that's not very likely. The defense experts, nice people, very sincere, but they're in a little silo. If those forensic pathologists can't cut on a dead body and come up with a smoking gun reason, then their opinion was they won't give you a cause of death or a manner of death. Even though Dr. Banerjee said, oh no, we don't do this in darkness. We look at all the facts. We look at all the circumstances. And the autopsy is just a part of the process of determining these things. But was it? Did she have any facts that were right at all? She had a few, but not many. And in her own report, she said, if other information is brought to my attention, I reserve the right to change my opinion. Well, she had a bunch of other information, but she still wouldn't change her opinion. Why not? That's just her mindset. Did she have any experience in insulin cases? This was her first case, her first one. Dr. Dragovich, apparently he didn't have any insulin experience either. Now, the defense told you that the state has just gone all over the lot with its theories. Is that your recollection of the evidence? Did you hear any state witnesses say there was one injection of insulin? No. Did you say multiple? Because we don't know. But there are some things that we do know. Now let's talk a little bit about how that balances out what the defense just told you. There's a lot of circumstances that need your consideration. First of all, this is a trained pharmacist, a pharmacist who knows about all sorts of medication, the impact of the medication, the dosage of medication. Beyond that, this defendant held herself out as a diabetes specialist. A diabetes specialist. That's another circumstantial piece of evidence to keep in your mind. On February 6th of 2019, on the basis of a supposed counterbalance to her cancer treatment, she needs to borrow a bottle of insulin. Another circumstance that needs to be held in the back of your mind. Because on that day, they were supposed to fly to the Bank of America. And yes, there is a merger with the federal case and this case, and that's where the merger takes place. You heard Trooper Heinzman discuss all of the things that the defendant had told her investors about the money that was supposed to be coming in, the money that was going to be coming in, the money that was almost going to come in, and it never did. Who else did she tell that to? Michael Cochran. So when the defense says, oh, he was up to his eyeballs in this, was he? Does the evidence support that? They have zero evidence to support that theory. Zero evidence. He did live a lavish lifestyle. But if he thought that the money was there for good cause and that the business was just supporting that lifestyle, was there anything wrong with that? Of course not. But this was a person who ran a Ponzi scheme. And the one thing you can count on for people that run Ponzi schemes is they will do whatever they can to keep it going. Is that what she did? That's exactly what she did. She was still shucking and jiving after Michael Cochran died. Right up until they executed the search warrant, she was doing ordinary business.
Say shucking and
selling
jiving.
the non-existent contracts, trying to get people to invest. So there is zero evidence that Michael Cochran was up to his eyeballs in this, but this defendant was up to her eyeballs and over her head in this fraud scheme, by their own admission. Second number.
21. There it is.
21. That's a big number. And that's the number we're going to rely on to convince you beyond a reasonable doubt that this defendant killed Michael Cochran. That number was the number of his blood glucose level at Raleigh General Hospital at 8:30, the day of his collapse. Now, unlike the defense witnesses, the state witnesses were unified and very clear as to what caused that 21 number. Dr. Krieger had 13 likely causes of low blood sugar, hypoglycemia. She eliminated all but insulin. And she's got a good reason for all of them. You heard her testimony. All of those were potentially valid causes of the condition that led to the brain swelling, that led to the death of Michael Cochran. All of them. But she eliminated by logic and by her scientific skills and experience in insulin cases that it had to come from insulin. Dr. Uribe, another experienced insulin investigator, Both of those two were involved in the Clarksburg VA murder cases where a nurse was killing veterans with insulin. Those two were the government's star witnesses. They know what they're talking about when it comes to insulin. And it comes to insulin killing people. That's what they do. So that 21 was never overcome by a single shred of credible evidence by the defense. Not once. No one's told you from the state that there were single injections, multiple injections. We don't know the answer to that. We do know that Michael Cochran's death was caused by insulin and reducing his blood sugar to a fatal level, and the resulting changes in his brain killed that man. Circumstantial evidence is the basis of this case, and let's get this a nice, straightforward example of what that is. It's January in Raleigh County. You look outside your window and you see frost on your neighbor's truck, frost on the ground. Stars are out, moon may be out. You go to bed. You wake up the next morning and there's 8 inches of snow on top of the truck and on top of your grass.
With the snow analogy.
Did you see it snow? No. Did it snow? You absolutely know it did. That's circumstantial evidence. Ladies and gentlemen, the state of West Virginia has dumped a blizzard of circumstantial evidence on this defendant. Until today, 2 weeks in an American courtroom, and until today, you never heard the word justice. Well, do justice for Michael Cochran. Find this defendant guilty of first-degree murder, because that's exactly what she did. Thank you.
You ran out of time. Had to wrap quickly.
Members of the jury, you have now reached the final stage of the trial. This is the point where I would ordinarily release the alternate jurors and send the regular jurors to the jury room to deliberate upon your verdict. I see that the time is almost 15 till 5. Ordinarily, I would close out the day at this time, as you know, and send you home for a nice dinner and watching TV and then going to bed. However, you folks are in the catbird seats. You are the judges of the facts, and you can tell me at this juncture what you want to do. And if you would like to retire now to deliberate upon the verdict, that would be fine. We will stay here, and we will wait until you reach a verdict. However, if you would like to start afresh tomorrow so that you've gotten a good night's sleep and you can think a little more clearly,
we promise donuts.
You can come back at 9 o'clock at the regular time and commence your deliberations then. We have talked among the attorneys about engaging in a powwow among themselves, and I would urge you to engage in a powwow among yourselves and see if you can reach some unanimity on what to do. Again, you can stay this evening and deliberate, or you can come back tomorrow. Perhaps you can confer for a moment or so and decide what you all would like to do.
Pregnant pause. Oh, do it right now. Apparently confer here in the courtroom.
I'm hearing tomorrow.
Okay.
All right.
So,
that's the decision I would
12%
make.
of
But
you
again,
are wrong. Just kidding.
I'm not you guys. I'm not going to release the 2 alternate jurors. I'll ask you folks to come back with us because I've been at this game a long time. and I know that anything can happen with jurors in terms of sickness and accidents and that sort of thing. We've done really well, and you folks have been great. You've been here promptly. You have watched and considered everything. I've been sneaking looks at you, and I noticed that you have done very well in terms of paying attention to the evidence and the proceedings. So I will ask all of you to come back tomorrow. Even though we have reached the deliberation phase, you still can't talk about the case because you haven't started your deliberations. And I'll tell you in the morning that you all need to be together. You all need to discuss the case together and not break up out into factions or have folks wander off. You need to talk about this together and share your concerns and share the issues that you have arrived at. So that will be to start tomorrow. I'll tell you about selecting a jury foreperson in the morning, and we will get down to business. So if you could all be back in your jury room at a little bit before 9. Do not discuss the case among yourselves. You're not at the deliberation phase yet. Do not talk about it to anyone else. Don't watch TV about it. Don't do any research online or see anything online. And please don't read anything in the newspaper about this case. Have a good evening, and I'll see you folks at 9 o'clock in the morning. You may follow the bailiff.
We'll have treats in the break room. With that, the jury said we're done for the day. We've heard all we want to, maybe a little more. We will not be making any decision today. We will not be deliberating today. We will not even pick our foreman today, or forewoman. Thank you. Did he make this? Can I show it? My son made me some art.
All right. Are there any matters we need to discuss at this time out of the presence of the jury?
Nothing from the defense, Your Honor. Thank you.
All right. Thank you very much. I appreciate your cooperation in this trial. We will return at 9 a.m. in the morning and see what develops. Court is adjourned.
And with that, we are done for the day. Let me just take a minute. My son just came in and made me some art. He made me this. It's green, so I have to show it on this camera. It's a hamburger. And when you pull it, it goes rawr, like that. That is awesome. That's really cool. Good job. Oh, you want it back? Okay. All right. That was interesting. That was very, very interesting. Just looking here. Just checking in with her family before they wrap up for the day. She didn't testify. I think defense, the closing was good. The state's closing was better. But for all the good points it had, it still just did not address the issues when the jury looks at that verdict form. And she's going to go back into custody. She is in custody. So when they look at that verdict form, what you taking with you? Extra cups. Little cup and a big cup. Follow the podium, ma'am. There we go. She gone. It's crazy to see some inmates let out with shackles, belly chains, and others just waltzing through the courtroom. Okay. I'm still in the same place. I have not changed positions or ideas on where I stand on this. I still feel this is a circumstantial case, and I don't think it's pushed it beyond the reasonable doubt threshold for me. It's well over 50%. I think it's very likely. I would even say it's probable that she killed him. because it fits the story, right? The story, the same thing we saw happen in Alex Murdaugh's trial, where his financial world was falling apart, and as it came crashing down, he had to have that distraction. He had to have that, take away the pressure. It fits. It fits like a glove when it comes to that. And that's why you aren't on a jury, says Purple Coconut. What I don't like about my position is it basically is me admitting that if you can commit the perfect murder, you're going to get away with it. That's what I don't like about that, because in my heart I'm feeling I think she did it, but as I sit and looking at from the juror's perspective, I say I'm not there yet, and I have to be okay with saying I think she did it and she should go free, and that's tough. That's tough for me. I would not be sad if the jury goes the other way, if they convict her. I would not be like devastated. It was like, no, they got it wrong. That's their prerogative, and I would wholly support whatever their verdict is. I would also not be surprised at all if we have a hung jury. We're going to close the poll out here. Should have done the poll after we found out the jury was not going to deliberate today, because some of you, about 10% of you said that the verdict was going to come in today. Apparently that will not happen. Now 66% say verdict is tomorrow after donuts. 14% say verdict on podcast Thursday, and another 8% say no verdict. Going to be a hung jury in this one. We'll see where this one goes. Let's see. We also have Yelly May, just because I'm able to hear about slapping ticks. Y'all, thanks for the giggles. We had some good one-liners in this one. I've loved this courtroom for that. I didn't know. Do you slap a tick? I mean, what? I've never had like what I don't know. I've never had a tick bite me. I have had a tick on me, like crawling on me, and it scared me to death, especially because it was. I went camping in the Wind Rivers in Wyoming. Beautiful, beautiful, rugged country. Amazing. I mean, just like when you say God's country, this is it. It is crystal clear water, ice cold, high up timberline stuff. Just amazing. Love it. Went camping there for a week. Had no tick bites. Came back, came home, took a shower, went to bed, got up the next morning, and there was a tick crawling on my face that jumped to the pillow. I don't know how that lasted, but I've never had one bite me. You can slap a tick, but it won't help. Yeah, they're like they're super strong. Like you'd have to literally like crush them, and even that's not recommended if they bite you. So use a spinny thing to get this. Yeah. Anyway, don't forget to show. Oh, Thurston case. We've got a case we need to show. Yes. Hang on. We're right here, right? We were in the middle of this. We were in the middle. Do we have to back up at all? Before we end the day, we have to finish this out. This is good. Hang on. Let's see. We've got Mr. Where are you at, sir? Got Mr. Ionish, and we're waiting for, and then Rachel on the bottom. The two on the bottom. The guy on the left in the blue is
all right,
the offender, supposedly. The one on the right is trying to get a restraining order.
Very familiar with Ms. Berglund's complaints or allegations, because we previously had a hearing at which Mr. Ionescu was not present. He has subsequently been served as present today. And what I've seen from the evidence submitted by Ms. Berglund is that she's repeatedly telling Mr. Ionescu to stop contacting her, and every time she does, he uses that as an he then responds.
He responds to the stop contacting.
Frequently request. Uses his state of mind as a reason for why he's continuing to respond. Mr. Ionescu?
He's like, oh, what?
Yes, Your Honor.
He's got good sound.
He in Tennessee?
He said yes.
the question. Are you in Tennessee?
Yeah. Yes, I'm in Tennessee. Yes.
Okay. You have. I'm pretty familiar with Ms. Berglund's case, so go ahead.
Oh, okay. Yeah. So first of all, there's a couple of blatantly false accusations here in this report that I'd like to cover. But first, I want to start with an apology. No. You're not speaking to her. This is not an opportunity. You are just addressing me on the legal issue of whether you have engaged in harassment. This isn't an opportunity to have any relationship with Ms. Berglund. So speak as to that issue. Right. I didn't think I was harassing her. I thought she welcomed most of my advances. I believed it at the time simply because, well, first of all, let me just say, she claims here that I went on her military base and that I tried to contact her and that I was hanging out in the area. Okay, that is a completely false claim. And I want to make this clear. I never stalked her. Okay, I never went out of my way to hang out where she might be or anything of that nature. Okay, that is a completely false accusation. Okay. Now, here in her testimony, she claims that that she told me repeatedly to stop over and over and over again. Your Honor, that's simply not true, okay? It's not true. I sent her over 115 emails in total, okay? She told me to stop one time, okay, around email number 63. Okay, now she was firm in her response. I will acknowledge that, okay? But Your Honor, I'm a hopeless romantic, okay? It's gonna take more than one response to get me to stop.
No.
You were told to stop. You can explain to me why you didn't stop. You said you're a hopeless romantic. Okay, go ahead.
Well, yes, but the reason I didn't stop is for two reasons. First of all, I continued sending her emails, but I also continued sending her money. Okay. Wow. I sent her financial compensation. And if you read the entire email thread, I don't know, did she submit like all of the emails or just samples from the emails?
What?
How would I know? I have emails here and messages.
Okay. Well, that's fine. The point is that I have no interest in submitting all of it because there's a lot of stuff there that's personal and deeply intimate. There was sort of an implied agreement between us, okay? She's my muse, okay? She inspires my work. I've explained this to her over and over and over again. And I was sending her money in exchange for the implied muse services. Oh. And if you really read the chain of events that happened, and it's all very well documented in those emails, okay? Miss Berglund accepted. I don't see any complaints about all the money that I sent her, but I can also show from the record, not only did she accept financial compensation for implied muse services, she also actively participated in rendering of muse services by posting photos on a social media account that are consistent with the content described in the emails, okay? So she was cooperating. Yes, after she told me to stop, she was actively cooperating. Now, I understand what happened at one point. No. I went too far, and I acknowledge that, okay? I got a little carried away with fantasies. It's true, okay? But there was a point after she asked me to stop where she seemed to me to cooperate with the implied agreement that we had entered.
The implied agreement
we had entered. I have this old school warrior conquer through persistence, overcome all obstacles mentality when I really, really want something.
Yes, this is true.
Yeah. And you said, I don't know why I keep beating this dead horse. It's time to move on. But, and then you have paragraphs after that where you recognize what you're doing. Then you say, listen, I've been extremely unprofessional. It's very inappropriate, but I will continue my conversation. So, and I'm looking at a prior email which says in all caps, leave me alone. It doesn't say, explain to me why you want to keep talking to me. It says, leave me alone.
Yes, but Your Honor, in the emails that followed, I promised her that she's inspired ideas that are going to make millions of dollars. And I offered to share my wealth with her, and she seemed like open to that suggestion at one point. Okay. Now, at some point, I got a little carried away. It's true. I'm a little too far. Okay. But the thing is, if you read the email chain, I told her over and over again, I said, if this bothers you, if any of this is like, you want me to stop, simply reply with the word stop. Okay. That's all she had to do was to say stop. And yes, I kind of pushed her because I was trying to provoke a reaction from her. I was not expecting this. I was expecting her to reply via email with a simple word, right? Because any normal woman, she's so stubborn. Like any normal woman would have just replied via email. She wouldn't go to this extent. This is absurd.
I don't think this guy knows what a normal woman is because he is not a normal man, in my opinion. I had to bring out the little pickle.
So I found it interesting that after you found out that being in Tennessee wasn't going to be the preventive measure to keep Ms. Berglund from seeking this order, when the sheriff showed up at your parents' house to serve you, you then responded by once again sending a rather extensive email to Ms. Berglund. After you already knew she'd taken legal action to get you to stop, you decided you needed to weigh in one more time, saying, okay, this will be the last time I do it. The last time I disregard your prior request will be this one. And you said, technically, I haven't done anything wrong because I wasn't served.
He still thinks he's
I wasn't there. So sort of like, nah. Yeah.
Well, I meant what I said. I'm moving on. I have no interest.
All right, that's a good thing.
In her anymore. And I want this matter to come to an end, and I will find a different muse. I will move on. There are plenty of fish in the sea.
Everyone run.
I was under the impression that she was receptive to my advances.
He scares me.
She was not.
What is he looking at? I don't even want to ask the question what sort of content he creates inspired from her social media, but the implied contract that I was sending her money, which meant that we had a contract because she kept posting to social media the sort of stuff that I wanted her to post. That just like... This screams out. The warning bells are ringing loudly in my head here. Miss Berglund does not even want to look at the screen that he's on. She's like, I'm so over this. I'm surprised he didn't key out his background and put himself on the beach or something. It's pretty easy to do. It was Sandra. Sandra's just here for, I don't know, for something else. Maybe next case. Rachel's the one asking for the restraining order against Simon in this case. Rachel in Thurston, Washington. Simon in Tennessee.
Ms. Berglund, is there anything more you would like to say?
You're muted.
You're muted.
Yeah, Your Honor, everything that I've submitted is true, and I trust your ability to judge the respondent's commentary as being untrue. If you have any specific questions that I haven't already answered, I can answer them, but I trust your ability to judge the situation.
All right, thank you.
Judge, you've seen this before. Please do the right thing. Simon gives the shrug. Whatever. Clearly has not found a new muse yet. I don't know the background on this story. Clearly, the judge has...
Based on the
Go ahead, Judge.
level of persistence, as you using your word, Mr. Ionescu. Am I pronouncing your last name correctly?
Yeah, pretty good. You're doing a pretty good job, yeah.
Honestly, I have a pretty high level of concern. I mean, frankly, I hope your family members are there with you, or they're watching on YouTube and they're finding out things that maybe would cause them the same level of concern and can help you with it. Because it's totally inappropriate, and you place Ms. Berglund in a position where she has a high degree of fear based on your inability to let go when she keeps telling you to stop, and you run right through that barrier. Every time she tells you, you say one last time, and then you continue. Anyway, it's highly concerning. It's behavior that we see in folks that end up in much more egregious situations, much more dangerous situations. And I want to make sure that you understand that, and that the behaviors I'm seeing are precursors and with some regularity to really bad events. So let's cut this one off before it becomes worse. I will grant the request for the order you are to have, and it's me telling you. It's not Ms. Berglund telling you in all caps. It's me telling you you're to have no contact with her whatsoever. You're not to go within 1,000 feet of her home, her workplace. Ms. Berglund, this order will be in effect for 1 year from today's date. If you want it renewed, you can come back to court and ask for it to be renewed. A copy of the order will be available to each of you in the district court file. There does not need to be service since Mr. Ionescu appeared in person today. All right. Thank you both.
Arguably, I don't think he appeared in person.
You're welcome.
Thank you, Your Honor.
Welcome.
Rachel's done. She's gone. Simon is letting it soak in.
Talia Woods, Brandon Williams.
I know Simon doesn't have another case
Ms.
here.
Woods, if you'd activate your video there.
Deep thoughts by Simon.
Ms. Woods, there we go. Thank you.
Is he haunting the courtroom?
Yeah.
There we go.
Okay, I have your audio. Yeah.
Okay, perfect.
All right, thank you.
Mm-hmm.
And if you both raise your right hands for me, please.
Yes.
Swear that testimony in this case to be the truth, whole truth, and nothing but the truth.
Yes.
Maybe he can't find the door.
And Mr. Williams? Is that a yes, Mr. Williams?
Yes, Your Honor.
Okay, yeah, we have to record everybody's responses, so I need out loud responses. Thank you.
He's gone. He's gone. Whew. He made his exit. Just wants to be, in case he get a chance to enter the last word. I think that's what he was hanging around for.
And
the judge booted him.
Ms. Woods, you indicated you went to Subway to get a sandwich and there was an issue, and ultimately that Mr. Williams got upset with, I'm not sure what, his belief that you mistreated staff or something, and then called you, you said 100 times?
Yes,
We have
so I
another.
have been receiving multiple harassing phone calls, and it started since November the 21st after I left that sandwich shop. And I believe that they may have given that phone number to like a family member or somebody. So all the numbers that have been calling me, like it was multiple threatening, harassing calls, and I made attempts to block those numbers as well. So when I trace, like look back at the numbers, it all goes back to Brandon Williams, and then it goes back to that same address. And so every day I have to pass this sandwich shop and I don't feel safe. I'm a single woman. I live by myself. And, you know, just passing it every day by my job, I just don't feel safe. I work 5 days a week and I have to drive past that establishment. And I've been receiving a high volume of calls still. So I have screenshots that I presented to show that I have been receiving multiple phone calls from those numbers. Some numbers are from block numbers, but when I pick it up, it's the same voice, and I'm indicating to stop calling me, stop harassing my phone. Each time I find out that it's that, you know, that voice on the other end, the same voice, same male voice threatening, I make attempts to block the number. And I just want to stop any form of contact. I just don't want any contact made anymore by this person. I don't want to be harassed anymore. And that's why I just wanted to put the legal proceedings in place so that I can feel safe.
All right. So you said you received calls from a variety of numbers, and you said that you did research on those numbers and they all came back to Mr. Williams. Is that?
Yes, they've all came back to that same person, same address. It's all from the same person. Yes.
Okay,
and it's
and
just
have you ever met Mr. Williams?
I have not met this person, but it's just been multiple phone calls from my phone. And when I pick up, it's the same male voice, and it's a threat, making threats, just harassing repeatedly, and just calls back to back to back. And then when I traced it, all the numbers come back to this person and to that address.
All right. Thank you.
Mm-hmm.
And what's the address it comes back to?
Yeah, so it comes back to
123 Sesame Street.
Address, and I have it. I have it screenshotted too, and I can share that with you as well. Let me find it here.
Okay. Well, let me just ask Mr. Williams, are you in Greenwood, Indiana?
Yes, Your Honor. I'm in Greenwood, Indiana.
Okay.
What are these out-of-state stalkers doing?
Mr. Williams, go ahead.
Okay. Well, Your Honor, I don't know if you had an opportunity to look at the evidence that was presented late. And this was because the first time I ever heard of anything about this case or what Ms. Woods is talking about is on the 21st of this month when I was served by the sheriff saying, hey, you've got this, this hearing to go to. If you look at the evidence, I don't know if you have it in front of you. Number one.
No, I don't have anything that you have filed.
Okay, Your Honor. The number that Ms. Woods is talking about that I'm associated with is not registered to me. It is a Verizon jetpack that was disconnected from me in 2023. And I have the evidence here, and you could probably see it once you're, we did file a little bit later, so that information is in there. But that jetpack, which basically just gives you internet, it's not a phone. So this is the number that is currently not connected to anything. And this hasn't been used since 2023. So that number is like spoofed number that
So he
someone
hasn't
is
done
using in order to make these particular phone calls to Miss Woods. Secondly, I live in Greenwood, Indiana. I'm not associated with anyone in Washington State. I haven't been to Washington State in over 5 years. I don't know what the Subway location is. I have no connection to anyone at Subway or anything like that. And so for Ms. Woods to claim in her statement that she did her research, I did research on that number as well. And it came back with, it was registered to no one. But I looked up my own phone number, my 360 phone number, and both of my phone numbers that she articulated in the in her statement came up with my name. And so my big question is, if she did the research, I don't know what research she's done, except the fact that maybe she went to see some public records that are like old names connected with phone numbers or old phone numbers. And she just took that number and associated me with it without understanding that it's an old phone number that I'm no longer registered to. And I think that's the leap that right now she's taking in order to unwittingly falsely accuse me of something that I have no idea what's going on about this. So, but
they'd never met.
Something that I looked at and the evidence from my perspective is when I looked at the statement that Miss Woods was saying that someone threatening called her from Subway, it was an unusual thing to go back into Subway after you felt so threatened that she went back into Subway to take on these people who apparently had said, I'm going to hurt you. And she goes back into Subway to face them. And it seems like there's a connection that I'm not privy to. And I'm being wrapped into it because instead of going through the Subway chain of command, if you were, it's just filing a petition against a phone number instead of doing the due diligence of finding out who's connected to the phone number, or even if that phone number is even active, because currently, Your Honor, it is not.
Okay. So in your testimony, I'm hearing you say you have no idea what this is about and you have not made any calls. You don't know Ms. Woods and you've not made any calls to her at all. Am I accurate? Is that a sworn statement by you?
That is correct, Your Honor.
Okay.
So somebody else using his number.
Ms. Woods, is this a voice you believe you've heard?
Yes. So, Your Honor, I would like to add this, that I filed a police report that same day. And so the police, they did do an investigation into the numbers and they did trace it back to Verizon Wireless. So when they did do the full investigation on that. And so I did also file a complaint with the owner as well. So the threat started after I left the shop. And so I did go and do my due diligence and I filed a police report and they did link it back to a Verizon Wireless user. And so when I did call Verizon Wireless, they did confirm that it is an active number from Brandon Williams. And so they also had all of those numbers that were linked to that particular person that was making the harassing phone calls. And then also I did look up and do research on Brandon Williams, the numbers and everything. And it also stated that their address was in Puyallup, Washington back in 2023. So it wasn't 5 years that they weren't, in Washington. And so where I don't feel safe, I would like to add that I don't feel safe because I'm still receiving those multiple harassing phone calls.
Absolutely.
And so when I did file a report with the police department, that's where they did trace back that number to that person. I do have the address. It was from a 1398 Thornhill Lane. That's where all the numbers are coming back to. So I'm still getting these calls. I personally, I don't feel safe. So when I entered into the establishment, the workers, they instructed me to write down my phone number on a piece of paper. And so I wrote down my number and I handed it off to them. And that's when, like when the sandwich was remade, the employees, they were very disgruntled. They were upset that I came back, and it was something, a really simple fix. And so when I left the establishment, that's when I started receiving the multiple harassing calls. And I did contact the owner. I let her know everything that was going on. I filed a report with her. I went straight up to the corporate level, and she was very much interested in finding out who was behind, these multiple harassing calls. And so when I did do research on this number, it said that their last prior address to Greenwood, Indiana was in Puyallup, Washington in 2023. So I don't know if they have a connection with the people at the Subway shop where they can easily come back or, carry out any threats. So the threats definitely started when I got in the car. I answered the phone, and that's when the threats started. And then that's when I did my diligence to contact the owner, and I made a police report that same night in response to that. Mm-hmm.
Thank you.
Okay,
Mr. Williams, is that the correct street address?
1398, Your Honor. However, the Puyallup timeline is incorrect. So the 2023, I have been living in Greenwood since 2020. As part of the evidence that was submitted, though late, it shows a deed for a home that we have purchased in Greenwood in June of 2020. So I don't know, the evidence that Ms. Woods is bringing up almost feels like it's hearsay, saying that she did all this research and the police did all this stuff. But the only thing that was submitted, as far as I could see, was a bunch of numbers saying that, block, 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 and then one number that was a previous used number on a jetpack on the internet that I owned back in 2023. So I don't know how she's putting these things together. We brought the jetpack from Puyallup because we still have our Washington phone numbers here. So maybe they're like, oh, well, that number is still connected to Puyallup because you have the jetpack in Indiana. However, the jetpack's ability to make outgoing phone calls is not possible. And the other thing is that we actually disconnected. We have a statement right here from Verizon from an old email saying that it is disconnected as of these dates with all of these phone numbers. So I don't know what Ms. Woods is getting her information, Your Honor, but it seems like I have no ability to cross-examine what she's saying. She can just articulate it here in court without having the burden of proof that I think she should have.
Okay, do you know Ms. Woods? Ms. Williams?
Say again, Your Honor, were you speaking with me?
Do you know Ms. Woods?
I do not know Ms. Woods, Your Honor.
Do you have any interest in any Subway shop anywhere?
Absolutely not, Your Honor.
I'm a Jimmy John's guy.
I have no idea I don't even know what Subway shop they're talking about, Ms. Woods was talking about. I have no connection to any of this. I'm just someone who is loosely connected to a phone number, and this is being the whole case for Ms. Woods.
Okay.
And Your Honor, I would like to add that while he says that all the screenshots, that there's no evidence that he's connected to it, the screenshots of my calls show that it is from that number, that 253 number. And when I called Verizon Wireless and when the detectives did an investigation, they linked it all back to that phone number and to that name and that address. And it's coming, and every time I answer it, it's the same voice and the same person.
See, you're convinced based on listening to Mr. Williams today that that's the one who's been calling you?
I have a history of multiple calls, and then it's coming from that number. And I can also provide evidence from Verizon Wireless stating that that number was linked to that person under his name, and also the detective investigation as well. So when I did my research, all of the calls are coming back from that same number. And
right. No, I understand that. The issue is, has that number been spoofed by somebody else? You've heard the same voice lots of times. The question is Mr. Williams a voice you've heard, or is somebody spoofing his number, which means they're taking his number and making it look like it's calling from his number, and they're the ones leaving you the messages? Do you have any way to determine between those two possibilities what has occurred?
So when I do answer the phone, it is that same voice. It's a deep male voice. It's the same voice that's calling and then making harassing threats. And each time I go and I block that number. So the numbers that are coming is all linking back to that person.
Right.
And so I don't know, like when I went to that Subway sandwich shop, there were 2 employees working that night, and I gave them my phone number. I wrote it down, and they were very disgruntled. As soon as I walked out of that establishment, and nobody was in there but those 2 employees that night. So as soon as I walked out of there, that's when I started receiving multiple back-to-back harassing phone calls. And this person knew exactly what I ordered, and they knew the time that I went in there. And it was just him. And then I blocked them. I told them to stop calling me, and it was just multiple people. Not multiple people, but the same voice that is on the other end. And I do identify it as the person that is here today. And once again, I just want the harassing phone calls to stop.
Hold on. Okay, I'm just having a hard time buying that it's, I know you're convinced today that it's Mr. Williams. What would be his motivation living in Indiana to do this? Any sense?
I feel that because the employees that were working there, when I came in and I placed the order,
now he's calling me.
And it was an incorrect order. They did my order wrong. And so when I came back to make a complaint about it, I felt that they were upset and disgruntled. The person that was there, she instructed me to give me her number and put it in. I'm just saying that once, when she went to the back for an extended period of time, and I feel that they wanted to do that as a way to get back at me for making a complaint. And I feel that she got a family member or a friend to do that.
Okay. So that's what you think has occurred.
Yes, and that's what has happened. That was and it was just ongoing, back to back, and it's still been going on, just multiple calls and back to back. And when I looked up all the numbers that were calling me, all of those numbers are coming back.
I know
that person.
I get that. Okay, Mr. Williams, what do you do in Greenwood?
My family have no family members that live in Washington. I have no family in Washington. Your Honor, I even have phone records from the...
No. What do you do? What's your job?
I am a life coach, but I retired from the Army in 2020, and I got a job in Bloomington, Indiana, which is why I moved here and bought a home. And that's why I'm here. I have no family in Washington. I have no connections in Washington. I have nothing in Washington to go and connect to, let alone go and harass Miss Woods about a sandwich, Your Honor. So this is a case of strong mistaken identity for whatever reason.
Okay, I get that. So are you a life coach? You're working out of the house? Are you working full time? How does that work?
Yes, sir. Right now I'm looking for clients, and anyone on here who wants to be a client, I love that. But right now I work as a
YouTube, so yeah.
As a health and wellness holistic coach, and I do that full time.
And the sandwich
right now,
artist
Your
on
Honor.
the side.
All right.
And Your Honor, I just wanted to add too that I worked 5 days a week as a registered nurse. And I would like to add that like just the harassing calls, that does limit me.
Ms. Woods, you don't have to convince me that the getting hundreds of calls is harassment. I'm totally satisfied about that. The question is, who's the one that's calling you? That's really the issue here.
Right. Understood. And Your Honor, I did work with the detectives extensively, trying to find the number and the person behind it. And I called Verizon Wireless customer service, and they did tell me that the numbers were registered under that name. So
I understand
and that person. So it's all the numbers that are coming back that are calling.
All right.
Your Honor, can my
Mr. Williams? Yeah, hold on.
Mr. Williams, you're done. You're done. You can go now, actually. She's getting calls, but not from Mr. Williams. And one part of the story doesn't add up. She keeps blocking the numbers, but they keep calling. All these numbers keep coming back to Mr. Williams. That part doesn't connect for me on the tech side. Unless Mr. Williams has a whole bunch of phone numbers. It seems to be only one that seems to link back to him. I should file a lawsuit because I'm not Dwayne. I'm not Dwayne. Should I just pick a random number to sue? Is that how you do it? Just find a phone number and sue them for calling you saying you're Dwayne? Oh. The thing is, I feel bad for her because there's no doubt. I mean, if she's getting calls of people saying, we made your sandwich wrong on purpose, you'll never get a good sandwich of this. Yeah, it's probably somebody at the store, okay? And it's probably somebody who has enough time on their hands that they can do that and care about it. And B, it's probably not a professional life coach out of, where is he, Tennessee? I forget, Georgia? Oh, my goodness. Yeah. Think this through. It's like, here I am. I'm like, hey, you messed up my sandwich. Can you fix it? And they're like, oh, fine. We'll fix it for you. Yeah, they're disgruntled. They fix the sandwich. But what do they do at the same time? Quick, call Uncle Williams. Let's see if we can organize a campaign to just blast her phone with threats. He'll be up for it. No. Oh, my goodness. I'm surprised he even showed up to court. I guess he got served, which, props to the police for finding him.
All right. There is no doubt in my mind that Ms. Woods has been harassed based on her bad experience at the Subway shop. The issue before the court is Mr. Williams the one whose phone number, whose name has been linked to a phone number, is the one who's doing the harassment. Mr. Williams lives in Indiana, has for a while, based on his testimony, and indicates he has no family members in Washington and no interest in Subway stores or any of the employees at Subway stores, unless he's hungry. So I'm not satisfied that there's sufficient evidence. The fact that it comes back to a number isn't enough in my mind. And unfortunately, with the continuing,
watch her get a call.
I'd say improvements, but I use that word carefully, of technology, the ability to make a call from one number and make it appear that it's a call from another number is pretty widespread these days. I believe that's what's happening here. I believe it's likely somebody associated with the store at issue, and somehow they got onto this number and are using it as a basis for calling Ms. Woods. So Ms. Woods, this doesn't solve your problem. I think right now we don't know who is originating the calls. I am not satisfied in any way that it's Mr. Williams who is doing so. I don't see any motivation for that. I'm going to enter a denial. I have entered a denial. I sympathize with you having to receive these calls. Honestly, I think that's up to you now you're going to have to change your phone number so that person doesn't have your number, and then the calls will end, or hopefully you've done that. But I think that's the only way to address it right now. So I've entered the denial. I'm not satisfied that Mr. Williams is the one making the call. You said you thought you identified his voice. I'm not convinced. I think you could identify a voice from 100 calls if you had known that was Mr. Williams ahead of time, but not afterwards. The mind will link those voices together as a way of trying to, prove something to yourself. But in this case, I don't think that's accurate. So
Your Honor, could I add something there before I move on?
You can ask something. I've already entered the order. I'm not.
Yeah. Understood. So, Your Honor, I would like to submit additional exhibits of the address and the name of the person with the numbers all linked to that same person, and then that also supports
No, I understand that that's exactly what would happen. That Mr. Williams' name is going to be associated with that address and that phone number. I have no doubt believing that.
But it wasn't.
Yes.
What I'm indicating to you is somebody else has taken that number and they're calling you probably from Olympia or Tacoma. And
we're in the bathroom.
They're making it seem like it's a Mr. Brandon Williams in Greenwood, Indiana, outside of Bloomington, who's giving you a call, and it's not. It's somebody else.
Mm-hmm. And then, Your Honor, okay. I'm sorry.
All right, Ms. Woods. Yeah, we can't. I have other cases I have to hear.
This one before you move on. I'm so sorry.
All right. Thank you.
Your Honor.
Thank you both.
Okay.
All right. Bye-bye.
Mr. Williams, can I at least give my website? Brandon Williams, lifecoach.com. He should have just shouted it out. Should have said, speaking of spam calls, I've got one now. Okay, I'm going to try my old person's voice. I'm not good at this. Hello?
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 Good afternoon, this is Lena speaking. I'm reaching out today to let you know about some of the most incredible free benefits that we have this year in the Open Enrollment 2025. If you qualify, you can get food cards, flex cards, and even cash back of up to $250. To verify your eligibility, can you please tell me if you have Part A and B of Medicare?
I think I've got hemorrhoids. I guess that's not a qualifying condition. Okay. All right. We tried. All right. We're done with this court. We're going to bail on that one. Thank you, Josh, for alerting us to the fun that's happening up in Thurston, Washington. Oh my goodness. Back-to-back court cases with crazy. Expands to standing table, says Ashley. Oh my goodness, wild ride today, crazy. We have verdict watch tomorrow morning, first thing in this case. So the Cochran case, it's going to be amazing. Natalie Cochran in West Virginia. The jury's going to be first thing in the morning. They're going to start deliberating. Don't know how long they're going to take. It might be a couple hours. It might be early. They might just want to see what's on the table for the snack in the morning. And if it's not good, they might have a verdict right away. We don't know, but it's going to be good. Thanks for all the advice. Take a sitz bath. There we go. All right. Wonderful. All right. Let's see. There we go. Oh, I've got another. It's Ricky. Hang on. I need to take this one.
Call from
Ricky Watson.
Ricky, how are you doing? I stopped.
I'm doing well.
I stopped the going away music for you.
Oh, sorry about that. Gosh, no.
You're good. What's happening?
Well, I mean, I don't want to pull your britches down or nothing, but
thank goodness
you're not very good at the old lady syndrome there.
That was my old man voice. That makes it worse.
It was kind of high pitched for an old man.
I was trying. I need a voice changer is what I need. Usually when you do that, you always do the
hello, you old whippersnapper.
Oh man, you got it. How much do you charge to answer my phone calls for me?
Oh, shoot, I wouldn't charge nothing. I enjoyed doing that.
Maybe we'll try. Hello? No, I can't do that. I'm trying to do the denture sound. Is that good? Hello? I can't. I've got to practice in front of the mirror. Ricky, do it one more time. Let me just get a good take on the old man voice. The whippersnapper.
All right. Well, there you young whippersnapper.
Okay, I'll work on that. I don't think I have that that sound effect in my repertoire, but I'll have to practice.
It gets easier. It gets easier once you do her for a bit.
Well, I haven't done it enough at all, so I'll work on that. Otherwise, I'll just find a machine that can just tweak my voice, and I can just say, make me sound older. So I need a voice coach, Teresa. I need a voice coach.
Gosh, dog! If you need to record mine, go right on ahead.
You've got it in spades. I cannot do that. Ricky, thank you very much. It's good to hear from you. Hope you're doing well.
Oh yes, sir. Appreciate you, bud. Hey. Everybody in chat, howdy, and good night, y'all.
All right, we'll see you, Ricky.
All right,
bye. All right, I've clearly got a lot of work to do to work on my voice impressions. I don't know what it is. Yeah. It's been a long day. It's an interesting day. We're finally at the end of the case. Excited for tomorrow. We should have a verdict. We should also have a new court case tomorrow. That'll be exciting. Maybe we'll have some sound effects. Cog, text me what I need. Cog, and there were some others. All right. We almost got to 1,000 likes. I don't know. We were so close. I guess that breaks the streak. You know, we thought we could do it, but bummer. Tonight when you go home, please hug the people you love, smile at someone, make their day just a little bit better, and please stay safe till we go live again tomorrow morning at about 8:30 as we prep for the jury to begin deliberation in the West Virginia versus Natalie Cochran trial. I think we'll have at least 3 hours of deliberation. I'm going to put that out there, at least 3 hours. So lunchtime verdict, maybe. Oh, the likes are climbing. It's 9. We need 49 more likes, or 39 more likes. 39. You can click the like on the way out the door. That would be great. Have a good evening. Be good to everybody. We will see you all in the morning. We are one day close. Well, tomorrow's hump day, so we get the hump day all first thing in the morning. Then the day after that is podcast Thursday night. So you've got your week planned out for you. 979. Here it goes. I've got to close it. 986. It's climbing fast. Can we make it 1,000? I just don't know. Y'all. Have a good weekend. 992, 1,000. Bye. We made it. Did I say weekend? Hang on.
Shame on you, sir.
Did I say weekend? I'm not gone yet. Did I say have a good weekend? I was planning my week. I did say weekend. I'm sorry. It was terrible. I do want you to have a good weekend, just not yet. Guys, have a good night. We'll see you tomorrow. Bye.
Have them send someone with more experience.